Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my left and your right is Justice Paul Smyth. On the video monitor joining us remotely as the third member of our panel is Justice Maureen Walsh. We will be the panel for all 6 cases that are on the hearing list for today's session. The first 3 cases we'll be hearing are criminal matters. We will take a very brief recess following the argument in the third case and then resume with the civil portion of our hearing list. Those of you who've been here before know the drill, but I will review it just as a refresher. Each side of the V has 15 minutes to argue. If there's more than one attorney arguing on either side of the V, please let us know ahead of time how you'll be dividing that 15 minutes. And there is no rebuttal. We're familiar with the arguments that you've made in your briefs, with the factual and procedural background as well. You needn't repeat all of that. We'll have questions for you. If you reach the end of your time before you reach the end of your argument, you can rest on your brief for whatever remains. And if you reach the end of your argument before you reach the end of your time, of course, there is no need for you to continue speaking to us. With those preliminaries out of the way, I will call the first case, case number 2023 P196, the Commonwealth versus Michael D. Thompson.
Good morning. May it please the court. My name is Patrick Noonan. I represent the defendant appellant Michael Thompson. In this case, the defendant's motion for required finding of not guilty should have been allowed. The evidence in this case did not show that at the time of my client's agreement to perform contracting work, that he did not have the intention to perform any work. That's the legal standard that we're applying in this case. I rely on Commonwealth versus Long, which is...
Let me ask you about the timing. The timing is critical as to the standard. And the parties first met, or the defendant and the victim, in June, I believe, correct?
Yes.
And the first check was in August, correct?
Yes.
In your perspective, or your point is that at the time they first met, entered into this agreement, there was no intent to defraud.
Exactly. And what I'm relying on, Your Honor, is that the proposal was basically the agreement that started this whole process.
What about, though, later on, by the time the check in, I think it was November 6th, that was the big check, $72,000. What was the defendant's intent at that time? And could not we review whether his intent to defraud was as of November 5th versus June?
And that was an argument that was raised in another case. I believe it was either Commonwealth versus Henson or Commonwealth versus DeRosiers. Both cases are cited in my memo. But what the Commonwealth tried doing in that case was to parse it out and say, well, maybe the defendant had an intent to perform work at the time of the contract, but then later on the defendant made a representation that he would perform additional work when he couldn't do it because he was in a car accident and sustained an injury. So the court said, we can't parcel this thing out and say, he may have had the intent to do it in the beginning, but then made an additional representation, basically starting a new contract or a new agreement, made a new proposal, but had no ability to make good on it. So it's either Commonwealth versus...
But the elements aren't tied to a contract. They're tied to a false statement or representation, correct?
I'm sorry, Your Honor?
The elements of the offense, they're not bound by the date of the contract. It's whether there was a false representation,
yes,
upon which the victim relied.
Basically...
And there may have been false representations, we'll hear from the Commonwealth, in November, which are distinct from June.
So So our contention is the binding agreement is the proposal that started this whole thing, and at that time, Mr. Thompson had the intention to perform work on that proposal. Later on, with that big payout check, which was the third check for the building payout, I think it was for $70,000+ to get the building. Mr. Thompson did have an intention, I would suggest, to get that building there because he did pay the deposit of $3,600 to Chief Builders to get that building constructed.
Let me see if I understand, though, correctly, because you're shifting positions a little bit, or else I'm misunderstanding.
Okay.
Let's say for the moment that he, in fact, that the evidence did not establish that he had no intention of proceeding with construction at the time the contract was signed. You're not contending that that element would inoculate him from criminal conduct, false representations, inducing the victim's reliance during the performance of the contract, are you?
I'm not sure I understand the question.
Well, suppose he had an intent, or at least did not, it wasn't proven that he had no intent at the time the contract was signed. But later on, during performance of, or during the pendency of the contract, he made representations to the victim. The victim relied on those and parted with money at a time when he knew full well that he was not going to proceed with performance of the obligations under the contract, and instead pocketed the money.
Yes.
That would be criminal, right?
Well, I think...
Regardless of the intent at the time the contract was executed.
I think that as things progressed, it wasn't as though he knew he couldn't continue to perform the contract because
That's not my question of what his argument was. My question is, if it could be established that he made a false statement on which the victim relied at a time when he had no intent to complete the contract, the fact that he didn't possess that intent at the time the contract was signed would not inoculate him from criminality on that subsequent occasion, right?
I think it does, because again, with Long, with Henson, with all that case law, it is the intention at the time of the agreement, and the agreement is the proposal that started this whole thing. And things obviously happened after that agreement.
Attorney Newman, let me jump in for a moment. Let's just say that we disagree with your interpretation of the case law on that point, that there may be different times in which, in any case, the elements could be made, right? So set that aside for a moment, that perhaps there's disagreement with your position on that. If we look to the contract, and I would tend to agree with you that in this case, the signing of the contract is the time we look to see what the defendant's intent was. There are cases out there that say we look at the whole, the actions other than the failure to perform, to see, because we rarely have direct evidence, what the circumstantial evidence is of the defendant's state of mind. So in other words, while we're trying to go back in time to when the victim relied upon these misrepresentations, right? We're not limited, would you agree, to just when the pen signed the contract to look at what the defendant's intent was.
Yes, so...
Okay, so my question to you is, I'm familiar with the case law, you know, is this a windowsill case or is this a mobile home case?
Well, it's...
Because, yeah.
So one of the cases, Commonwealth versus Wright, was a mobile home case where the defendant was contracted to basically deliver a mobile home to the victim, and obviously had no intention to do that when he was contracted to do so, because he never ordered the mobile home and he never delivered it. In this particular case, the defendant did have an intention to follow through on getting that building to the job site because he ordered the building and he paid the deposit to get the building, and he provided the specs and the measurements in order for Chief Building Company to construct that building. So I don't want to sound like a broken record, but I think we have to look at the timing. What they say on element 2 is the timing is critical. The timing is the original proposal, the original agreement. Of course, this court can consider everything that happens in the whole grand scheme of things to see whether conduct or statements or anything made after the original agreement would show the defendant's intention going back that he had no intention at the time of the original agreement to perform the work. We can definitely look at that.
You agree on that, that subsequent conduct can illuminate the intent at the time the contract was executed?
Absolutely, and the case law makes that clear, that we can look to the circumstantial evidence to show what had happened.
But a more nefarious interpretation of his payment of the deposit to Chief was that that was a necessary element of his objective of getting the larger payment because he had to kick the can down the road and keep the ball moving.
Well, I believe he made the deposit for the building before he got the third check for the
I understand. He had to do that in order to ask for the third check.
Well, if he had no intention of doing it, he could have just kept that money, the $3,600.
Yeah, but with all due respect, the $3,600 was small potatoes compared to the fraud that he actually was successful in executing.
But I don't think this was I don't think this was a calculating type of person that knew that, hey, listen, if I'm going to cover my tracks here, I want to order this building, I want to put $3,600 down to make it look like I have the intention to do this because I'm really intending to just take
I want the golden egg, I want the pot of gold at the end of the rainbow, and I can't get the big cheese unless I make the deposit.
I'd argue most respectfully that's not a strong inference to draw against the defendant in this case because there was.
It's not a question of whether it's a strong inference. Is it a permissible inference for a rational fact finder?
I don't think so because we had the testimony of Mr. Hickey about my client's prior performance as a metal building contractor, and Mr. Hickey had testified that he came across my client.
Well, his prior involvement with Chief doesn't help you all that much if you include as part of that his engagement as a what do they call him, a chief builder or something like that, and as part of that relationship, he understood that it was unnecessary for the ultimate purchaser to pay for the building in full until the time of delivery, and yet he required that from the victim, that payment.
So yes, you're right, but he also, there was, he could have paid Chief the rest of the money for the building where it was cash on delivery.
Right.
So he could have brought it to the site, paid him on the site for it, obviously didn't. But I think what happened was when we look, when the court's talking about, let's look at conduct that was after the fact, after the agreement was made, you know, the alleged victim said that my client's comments to him, you know, when things weren't kind of progressing the way he wanted to, he said he's like, I'm behind, I'm a poor businessman.
Well,
you know,
yeah, but I mean, so during that period, the evidence showed he was saying one thing to Chief, and a completely opposite. He's telling the victim there are problems at the manufacturing end and delivery is going to be delayed. And he told Chief, "Don't deliver yet. We're not ready at the job site," which was again intended, a rational jury could infer, to push the can down the road.
Right, until he could scrape together the money to get to Chief to get that building.
Well, he had the money.
site.
He got it from the victim.
Right, and there was evidence that he was in the metal building industry. He had several other jobs that were going on at the same exact time as the job that he was doing for Mr.
That gives him
DiDominici.
motive, not immunization.
Well, I think it's relevant to show that the guy has a metal.
Yeah, could I interrupt for a moment?
Sure.
You agree with what the standard is? The Chief has just elucidated, right? Or review.
I would have to say that the standard is the intention at the time of the agreement, the proposal.
So when the appeals court reviews a denial of a motion for a required finding of not guilty, you would agree that we look at the facts in the light most favorable, in this case to the Commonwealth, obviously, and all reasonable inferences to determine whether a rational trier of fact, generally a jury, could find the elements, correct?
Sure.
Okay. And so while I find your written materials good,
Thank you.
it's not helpful to me at this argument for you to be arguing to the degree what the jury found. So given the standard, it's not that, well, this evidence could be I'm a bad businessman, or this evidence could be that I meant to pay, I just kind of got tied up. We must review all the facts in the light most favorable. So your argument, you need to win arguing with the facts in the light most favorable to the Commonwealth and telling me why even if we review all the facts in the light most favorable to the Commonwealth and all reasonable inferences, it's not enough.
Yes, so what I'd like to say is when that agreement was made, the defendant did right away perform work towards that job. He met with Mr. DiDominici 3 to 5 times. He went to the property. He inspected it. He got the dimensions. He got the measurements because this was a very specified building for the alleged victim to build. It was going to be a big building, a holistic medical center that he wanted. In order for that job to be done, 2 things needed to happen right away. First, there needed to be preliminary drawings of that building, and second, there needed to be certified stamp copies, certified stamp drawings of the building. Mr. DiDominici paid his first check for $16,000 for preliminary drawings of the building. My client performed that work, got those preliminary drawings over to him. Mr. DiDominici reviewed those, approved them, and he paid for those drawings, and he got those drawings. So that agreement, that term of the agreement was met right away. And the second part of it, the second check was for the stamp drawings, and that was a check for $5,355. My client, again, did the work, which generated the stamp drawings. Mr. DiDominici received those stamp drawings, paid for them, got them. So those 2 things were done. Mr. DiDominici got the benefit of his payments for those 2 things. And if Mr. DiDominici hypothetically wanted to hire somebody else to do the job, he could still use the preliminary drawings and the stamp drawings that my client had done for him. And then Mr. DiDominici said, well, you know, the second check for the stamp drawings, that was also an issue to get permitting for it, permitting for the building, and there was no evidence that the Commonwealth had put in that the defendant didn't get the permit necessary to put this building up. So those 2 things are very significant because those were 2 checks for 2 very specific things, 2 things that my client did, and 2 things that that alleged victim had received. And the alleged victim admitted that when he spoke to Chief Building by email, he says, well, I gave you a check for $16,000. Those were preliminary drawings, and I got them. I paid you a second check for $5,355 for stamp drawings. I received them. I got them. So he got those 2 things. And this isn't so those are fulfillments of.
I think you're going to have to leave it there.
Okay,
I'm rest on your brief for the remainder.
I do have 42.
Oh,
I'm sorry, I'm over.
It's running the other way.
Okay,
Yes.
thank you. I'll just rely on my brief. Thank you so much.
Thank you.
Thank you, Your Honor.
May it please the Court, Carolyn Burbine for the Commonwealth. It's the Commonwealth's position that there was sufficient evidence in the light most, viewing the evidence in the light most favorable to the Commonwealth at the close of the Commonwealth's case.
Why don't you start by addressing the defendant's argument that the performance of at least a portion of the contract shortly following its inception demonstrates that, in fact, this is not like the other cases where they signed the contract, took the money, and went away.
Well, we have the contractor cases and, as Justice Walsh said, the mobile home cases. So the contractor cases, you know, you have the agreement, they come, they do some work, it's perhaps not up to par or it's not done as quickly as they've liked, and there becomes a dispute. Here we have a scheme, a plan to defraud. So we get evidence from Mr. Hickey that the only thing that the victim should have had to do to get his drawings was pay $3,600. And then, so what would happen was the defendant would enter the specifications in the computer, Chief's computer program. It would spit out the initial plans. They'd be approved by everyone, including the victim and the defendant. And then everything else would be done by Chief. Chief would get the engineering, stamped plans, everything else that would be needed. But what was represented by the defendant to the victim in that proposal was, I need $21,355 for a deposit on the building, and then there needs to be another payment of $72 plus for the building payoff. And the victim agrees. So the work that the defendant did is not like those contractors coming in and starting the job and doing some amount of work that was promised and then falling by the wayside. This was all part of the scheme. And what the victim is told and then the scheme continues. So the defendant is doing the bare minimum to get those plans to the victim because he knows the victim knows then he needs stamped
Let me ask you,
plans.
you've used the word scheme a few times, Counsel. In a number of cases you rely on, there was a scheme. It's in, I think it's Chirmoka. Not pronouncing it right,
Chirmoka.
at 66 Mass Ave Court 776. I think it's Justice Link. They refer to the swindler, for instance. And in Wright, there's no evidence. It's a different case Justice Walsh referred to. That's the mobile home case where there was no evidence to negate his fraudulent attempt. But here you'd admit, Mr. Thompson, he ran a business. He had a crew of about 6, correct? At the time he entered this contract.
I believe that was his testimony. I'm not sure if that came in the Commonwealth case, which is where.
Well, the testimony, the chief.
He did, I'm sorry, he did have a business and he did have a crew. You are correct,
And
Your
Mr.
Honor.
Hinton, I believe it's Mr. Hinton, also hired him or contracted with him to be a chief preferred contractor. And there was evidence he'd done a prior job, a prior building, a metal fabrication, correct?
Right.
So there was a lot of evidence he was a business person. He's testified he's been doing this for 20 years. He might have been found by the parties looking for him at a job site. So he doesn't fit the classic swindler to me, or the classic person who would meet with someone in June and have a scheme to defraud this person. He was a builder, wasn't he?
But I think that what you have to look at is this scenario, not whether in the past he was a swindler or if he has a history as a swindler. It's like, what happened here? So he's worked for Chief, so he's done a successful job for Chief. So the inference is he knows Chief's procedure, he knows Chief's payment structure. So why then is he giving this man a proposal with these huge numbers, and yet he must know, having worked for Chief before, that all this guy needs to really pay him is $3,600, which he can send to Chief, and Chief will do everything that the victim needs done,
Well, that doesn't mean
including
he's
build the building and
restrained to
deliver
only
it.
asking for that amount. I mean, he could also pay Chief cash on delivery because of his relationship with Chief, correct?
Yes, but I think what we look at is, well, I know, what we look at is everything that happened. So as the victim is giving him these checks, he's telling the victim, this check on 8/15, $16,000, is a deposit for preliminary drawings and to build it. This check on 9/10 is to print the secondary engineered drawings and to build it. Well, he has to give those engineered drawings to the victim because the victim knows he needs them for the permit. And then he tells him he needs that final payment for the delivery, knowing that he's going, and then he changes the delivery date. So you have all of this, and he doesn't tell the victim that he's changed the delivery date. And then after that, he's telling all these stories to the different stories to different parties.
Accepting all of that, what's his end game? If that's, I mean, you know, he may have been trying to bridge through, as he, as the defendant argues, bridge through a rough patch, hoping, maybe unrealistically, that he would be able to get to the other side, but not. You know, I mean, if we flip things around and assume that he was intending to defraud the victim, typically the people who do that disappear immediately.
Well, I think what we have here is, I think the bottom line is we look at it in the light most favorable to the Commonwealth. Well, that might have been a possibility. There's also, viewing it in the light most favorable to the Commonwealth, this was a swindle. And it's very much like, really, when you cut to the essence, it's very much like the mobile home case. You promise someone you're going to order them a mobile home. You tell them, I need the money, and I'll get you the mobile home. Here, he said, I'll get you a metal building. Give me the money. I'll get you the metal building. He didn't get him the metal building. So it's really not, it's not like those contractor cases. It's
different. Let me interrupt for a moment and apologize because of the virtual nature that I'm continually interrupting, but I'll make it fair. I'll interrupt on both sides. To some degree, when I read your brief, I say, Commonwealth, be careful what you ask for. Right? Because if this is sufficient evidence to prove a criminal offense, not a civil breach of contract, 93A, blah, 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 open your doors to thousands of unhappy handymen and women, window repair people. Keep going, because if this is enough, if you are a prosecutor in the district court, like some of the panel members were, or a judge in the district court, get ready. for every unhappy customer who deals with someone that belongs in civil court. This is what you want. If you say, this is enough.
I respectfully disagree, Your Honor. I think this case is different from those contractor cases. I don't think that entering that information in a computer constituted work sufficient to be parallel to those contractor cases. I think in those contractor cases, the court is careful to say dissatisfaction with work performed is not enough. You have to look back at the original agreement. And I think here, when you see the defendant's experience with Chief, how he knows how it works, the way he structured it.
Yeah, if I contract to have a porch built on my house, and I hire contractors and they say, every month you're going to pay this amount, and they front the money to other projects that they're working on, and the bottom falls out.
Well,
That's enough, right?
Well, I think
that's enough, because how is that different than this case? So in my instance, sure, they could have waited, but they say, you know what? Here's your schedule of payments. Half down now. When we do half the work, half, and finished the other half, they take my money. They buy equipment for some other project, and then the bottom falls out. That's enough for a conviction for larceny of false pretenses?
I think the cases show that you still, you have to go back to the original agreement, but then the court will look at what, the amount of work that was performed and the whole big picture, and
Yep.
they also look
my
at
case
consciousness
none.
of guilt.
My case
He's
none.
done no
The
work?
porch isn't built. Yeah, no, nothing. They took half. They bought some things for other projects because they're up and coming, but they just miscalculated. They're bad business people, and half my time's gone. I have a porch. I go to the DA's office and I want a criminal prosecution.
Well, we would
That's
still have
enough.
to prove that they intended it at the time. And then if like here, we can do that, which is our position, then in those contractor cases, then if it fits the statute and that's our job, then we're going to have to prosecute those cases. But I believe that, if it ends up we're inundated, then we're inundated because that's what the statute requires.
But what differentiates this case, I guess, from other civil breach of contract 93A? What's so different about this case? What evidence is enough?
Well, I think we met it with the original proposal, his knowledge that this man only needed to pay him $3,600 to accomplish the goal, and yet he keeps taking money. He keeps making promises along the way. It's coming, it's coming, it's coming. But he's telling Chief different things. All of this shows his intent to defraud. And so I would argue that from start to finish, when you look at the big picture in the light most favorable to the Commonwealth, we meet the criteria under Lattimore to show that he made a false statement of fact. He knew it was false when he made it. He intended the victim to rely on it, and the victim did rely on it and is out $93,000, $93,000 plus dollars. So I think when you look at the entire picture, which is what the cases require, we have met our burden, particularly where you look at it in the light most favorable to the Commonwealth, to show that there was a larceny by false pretense on the part of the defendant.
So on what date was that statement made?
I'm sorry?
Date's not an element of the offense, but what is your theory of when this false statement occurred?
I think the contractor cases make it at the time the agreement was made. So if you view it as the time that the proposal was made, then that's that. But I would also argue that if you don't think that that's the correct starting point, each time he took a check, he made a false representation. The building's coming, here it's coming, I'm working on it, and they're building it, and it's coming, and then the man ends up with nothing. So I think whether you view it at the time of the proposal, or if you view it with the first check,
But those checks were paid in accordance with the timetable set out in the contract, right?
The defendant set those dates and times.
At the time of the contract.
At the time, I believe at the time
So
of the
that the
contract.
subsequent statements, although incidental to the payments, were not necessarily inducements because the obligation to make those payments at those times was already baked into the arrangement.
They're tied to the original arrangement, but the defendant kept making, the representations. And so the 21st deposit on the building, the defendant broke it into 2 payments and said each one was for a drawing, which he knew he had to give the victim, or the swindle would fail. And then the final one, he took all of this money and never turned it over to Chief and made different representations to Chief as it progressed. So the original proposal, it's our position.
But the distinction is whether that sort of trajectory operates to illuminate his intent at the time of the contract, or whether it constitutes independent criminal acts.
Right.
Which is it that you are pressing?
So our position is, at the inception of the contract, viewing everything as a whole, you can see that the false pretense was right in the proposal, because it set the stage for all that followed. So we feel that we have met it at the point the proposal was agreed to.
Well, we've covered the issue. I would just add, though, that the complaint alleged the date of August, which was after the inception.
So that was the first
I believe it was the
payment.
date of the first check.
That's interesting. I don't know what to say to that, Your Honor. We didn't brief that. Would you like us to brief what the import of that
I'm sufficient.
would be?
No,
No?
we'll sort it out.
All right.
Thank you.
Thank you so much. Have a nice day.
Our next case is case number 2022 P969, the Commonwealth versus Michael A. Shehadi.
Good morning. May it please the court. Matt Spurlock for Mr. Shehadi. There is no dispute that the brick-like stun gun at issue in this appeal does not resemble a handgun, a short-barreled rifle, or a short-barreled shotgun. And for that reason, the plain and unambiguous statutory text of the definitional statute expressly excludes it from the definition of firearm. Now, that text reads in pertinent part, the term firearm shall not include any weapon that is constructed in a shape that does not resemble a handgun, short-barreled rifle, or short-barreled shotgun. That definition is mandatory, shall not, it's all-inclusive, any weapon, and it is as plain as day. When the text is clear as it is here, the court construes it and applies it according to its plain meaning. Now, the only exception to that rule is the absurdity doctrine, and that appears to be what the judge below ruled on. But that doctrine really has no application here. That doctrine applies only—
I'm sorry, when you say it appears what he ruled on it, Justice Doolin made a margin order, correct?
Yes.
And how are you inferring he relied on the
Well, that was the Commonwealth's— so far as I can discern the Commonwealth's argument below, that was the Commonwealth's argument.
Okay,
So
very good.
I
Thank you.
apologize. I should have put it that way, perhaps. It was the Commonwealth's argument below, so far as I understand it, that this result, the plain text result, would be so absurd that the court could not construe it as written. Now, that doctrine has no application here because it only applies when the text as written, the plain text, is so irrational, that it would be inconceivable for any rational legislature to make the distinction, to wrote what they wrote. And that's just not the case here. As I've explained in my brief, there's a number of reasons why the legislature could have and did rationally make the distinctions that they made and draw the lines that they drew. I can, run through them quickly now.
Well, I think if you put some of the legislators who voted on the amendment in the context, if you put them on the stand, and they roll back their memory to the context in which they adopted that legislation, I doubt that you would get many of them to adopt the alternative explanations.
That may be, Your Honor. There's certainly the Commonwealth has advanced no legislative history, no statements of legislatures. And in any event, that's not the test. The test is not, what they were thinking at the time. The test is what they wrote down, and then would what they wrote down survive rational basis review? That's another way to think about it. And so all of the cases describe it that way. Was this so irrational? Was it just inconceivable that this line would be drawn? So, and that test is just not met here at all. The Commonwealth doesn't even attempt to meet it. What they really have is a brief about their policy preferences, about why.
Well, I mean, the presumed legislative policy preferences, that couldn't possibly be what they meant.
Yeah, but that's not the case. The test is not, was this possibly what they meant? The absurd results doctrine is, could any rational legislature have meant this? Not, let's try to go back and see what the legislature actually meant. That's not what absurd results means at all. So, and it would be totally contrary to all the case law that I'm aware of to apply it in the way that you're suggesting, or that, this hypothesis.
I'm not making a suggestion, I'm asking.
Yeah, or the hypothesis against the plain text of the statute. It would be atextual, a countertextual construction. We don't have ambiguity here. Now, if the court, does discern any ambiguity in the language that I quoted, and I just can't see how that could be the case when we have any weapon, shall not include, that does not resemble a handgun. Even if there was some ambiguity, the rule of lenity still applies. So, under that hypothesis.
Is ambiguity necessary as a predicate to the rule of lenity, or is a countertextual interpretation based on the absurdity doctrine an alternative means to get to the doctrine of lenity?
Well, I think that there's a due process backdrop which is closely related to rule of lenity that does the same work. If the court was inclined to construe the statute against its plain text, so it's what it says cannot be what it actually means, and you still have a due process where it would not provide any reasonable person with fair notice about what is required under the law. In fact, a person sitting down to read that law would come to the exact opposite conclusion, that actually this stun gun, which does not resemble a handgun, is a firearm, which is not, the statute says the exact opposite of that. So that the due process, would also be a backdrop. Of course, there's also a statutory and constitutional mens rea that's required. Right in the statute, you have to knowingly possess a firearm. I cited the flare gun case in my
Sampson?
Exactly about that, and the court said, listen, we're not going to go there. If we went there, it would create serious constitutional problems, and that was, after that was based on the statute, but also the Constitution. So basically, any road leads to the conclusion that this motion to dismiss should have been allowed. Either the statute is clear and unambiguous, which it is, and it needs to be applied by its terms, or if there is some ambiguity, then you have the rule of lenity, and you have the due process backdrop. Now I'd like to, offer just some of the reasons why this statute is, as written, is not irrational and not absurd. Guns, stun guns that are firearms, the ones that look like handguns, are much more dangerous than stun guns like these, the ones in this case, that do not look like firearms.
Is that inherent in the appearance? I mean, it may be true as a matter of fact. I don't know anything about it. But it's hard for me to understand why that is necessarily the case, and why, if we're talking about the legislative intent, the legislature would expect that disparity would persist.
I want to be clear that I'm not talking about legislative intent. I'm not trying to get into the legislator's head.
Well, you're talking about why there may be a rational basis to allow stun guns that don't resemble firearms.
Certainly, but which is different than trying to get into the legislature's head.
I respect that distinction, but the point remains the same. The mere fact that at present time, again, I don't know, but I'll accept your representation that stun guns that don't look like real guns are not as powerful.
That is
maybe a present accident. I mean, there's no reason in the world why a stun gun that doesn't look like, that has electrodes at the end of or whatever they use, some kind of charge-emitting device at the end of a pole, couldn't be made much stronger than a stun gun that looked like a gun.
So the distinctions drawn in statutes are commonly both under-inclusive and over-inclusive. And the fact that that is just a fact of reality because the legislature can't anticipate, design and technology move ahead does not make a statute irrational. And so certainly it's possible, it's conceivable that a stun gun that is not a firearm because it doesn't look like a handgun could be potentially in the future designed to be as dangerous as the ones we have today that look like handguns and are therefore firearms. It could have full body incapacitation. I cited a number of federal cases that make exactly the distinction I'm describing right now. So there's the other distinction, which is where form does follow function, and it's the fact that those stun guns that do look like handguns and are therefore firearms are much more likely to intimidate and be mistaken for an actual firearm. So that's just one more rational reason. All I need is one. All I need is one rational reason why any legislature could have done this. The plain text of the statute says what it says, and what it says is that any weapon constructed in a shape that does not look like a handgun cannot be a firearm. That's what the legislature wrote. That's what they enacted. Now, I'd like to address again, coming back to the fair notice issue and the due process issue. The Commonwealth, in response to my due process argument, made the argument that my client would have been on notice based on regulations that were passed in January of 2023 that purported to require license for all stun guns. They call them electronic weapons there. Now, of course, that doesn't answer the due process issue at all because a statute passed or promulgated in January 6, 2023 cannot put someone on notice in August 2021 when my client was arrested. But of course, there's another problem that regulation is itself probably overstepping the authority that the agency has to make regulations. In fact, you cannot get a license for a stun gun that is not a firearm. The statutes that regulation is pointing citizens looking at it to is, yes, go get a license to carry for a firearm. But by definition, you cannot get a license to carry for a stun gun that is not firearms. So the statute that the legislature passed, the statutory scheme is as follows. Some stun guns are firearms. Stun guns are firearms if they look like handguns. Stun guns, and indeed any weapon that is not constructed in a shape that does not look like a handgun, a short-barreled rifle, or short-barreled shotgun, cannot be a firearm. And therefore, it is not punishable under 10A. Now, it's also not the case that this is a completely deregulatory scheme. As I noted in my brief, this may be possession of a stun gun that is not a firearm may be punishable under other statutes. Currently, we have 10B, which says that dangerous weapons, when possessed upon an arrest for breach of the peace or upon arrest with the warrant, are punishable under that statute. And of course, that's not a mandatory minimum right here. And the last issue I address, unless there's any questions, is the notion that the legislature couldn't possibly have intended this because I suppose it's a gloss on the absurd results doctrine because clearly they wanted to just do the next best thing after the old 131J was struck down in Caetano and Ramirez. But the fact is that whatever the legislature did or whatever happened after that was going to change the status quo. So on the Commonwealth's reading of under countertextual, under atextual reading, what it's asking the court to do is, in fact, rewrite the statute to add words to the exclusionary clause. Any weapon except for stun guns would be one example of, I guess, what the court could do. I'm not aware of any case where a court has taken the judicial pen and rewritten the statute in that extreme countertextual manner. But if the court were to do that, what the Commonwealth claims that was done by this would be to require a mandatory minimum a very harsh mandatory minimum for possession of stun guns. Whereas, recall that the old 31J, there was no mandatory minimum there. So there's also, to the extent that we're going to get into legislative intent, which we don't have any evidence of, except for just the history, which nobody denies, but there's no legislative intent. We have no evidence that the legislature intended to impose a mandatory minimum on possessors of all stun guns, right? Certainly, and even stun guns that don't look like handguns, that are significantly less dangerous than handguns, and less dangerous than stun guns that are firearms. So that it would also just take a leap of faith to rewrite the statute in the way that the Commonwealth is proposing. Unless there's any other questions, I'm rest on my brief.
Seeing none, thank you.
Okay, thank you very much.
For the Commonwealth?
Good morning, and may it please the Court. Andrew Doherty for the Commonwealth. I would like to acknowledge legal intern Bryn Morse, who wrote the brief here. I'm asking that the Court interpret the exclusionary clause of the firearms definition to only apply to the gun-type weapons that it applied to immediately before Ramirez. I recognize and agree that this is a difficult statute to read on its
Well, it's
face.
actually not that difficult to read.
Well, it's difficult to square with, and yes,
It's difficult to read and have the words say what you want us to see them to say.
yes, however.
Because the words, in fact, I mean, you don't challenge the defendant's observation that the words, in fact, say the opposite of what you're urging.
Well, I wouldn't say that they say they're opposite. It's not as clear, I think, so that they are not clear is not the same thing as saying they are ambiguous such that the rule of lenity applies. Right?
I'm not yet at ambiguity. I'm at clear exclusion. Right. So let's start. If you have a textual basis to illustrate that the exclusion doesn't apply to this type of stun gun.
Sure. So I think, and I recognize and concede that a literal reading of the firearm definition, if one were just to look at that, would
based on the words.
It's of that particular part of the firearm licensing scheme. It creates some controversy here, and because I don't want to marry a word here, because we're going to get to, yes, it is ambiguous, but not in a legally ambiguous sense. It is unclear. It tend to indicate what the defendant would like you to believe that it says.
Well, the words describe an exclusion, which, taken in application to this instrument, embraces this instrument within the scope of the defined exclusion.
It does, but what the court is doing by simply looking at that without looking at the entirety of it, in the light of what the legislative intent was, which was part of this analysis, you get to the absurd result that the Commonwealth is arguing here. So yes, were this a satellite, and we were simply looking at it independently of the entire scheme and why it was promulgated, yes, there would be the literal reading of this statute would tend to show that, or would show that a stun gun that doesn't look like a handgun would not be a firearm under this definition. And yes, I am.
Can I interject for a moment? I'm confused. I thought in your written brief you agreed that the statutory language was unambiguous. Is that true?
When I say unambiguous, I mean unambiguous in the total sense, where ambiguity is found when there is misclarity in the language and when viewed in light of what the legislative intent was. And so that's why I'm trying to be very careful about the use of the word ambiguity. And yeah,
but you're wanting your cake and eat it too, to some degree, right? Because basic tenets of statutory construction, if the language is clear and unambiguous, then we don't get to legislative intent and all the rest. It's like you're bridging the gap. Let me just finish my thought before I cut it, because I do want you to get back to it. How do I get around the fact that if this language is clear and unambiguous, our role versus the legislature's role is to apply it unless it results in an absurd result, right? So you're asking us to take a shortcut on that basic tenet of statutory construction.
I disagree that I'm asking you to do a shortcut. What I'm asking you to do is read the plain language of the statute with an eye towards what the legislature intended, which is different than saying it is, the case is talking about a literal reading of the statute being at utter odds with what the legislature intended is the absurd result that we're looking at.
But let me just cast what you're saying in words that you're trying to avoid using. I know what they wrote, but that can't be what they meant.
I think, frankly, that may be the best way to make my argument.
Thank
here.
you. I will tell you that in my view, it's not all that good.
I'm glad that I didn't write the statute. However, you have to credit the legislatures. You do have to view the language that they wrote in light of why it was written, how it was written, and in light of the entire statutory
let's go
scheme.
back a little bit. I mean, that one could argue that they probably didn't realize that stun guns weren't included originally, and then when it was pointed out to them, they amended the statute. Statutory restrictions are iterative by their nature. There are lots and lots of instances where the legislature has, upon discovery that the statute did not accomplish what they had intended to do, promptly takes action to correct that gap.
Right, but where it is so plainly obvious what the legislature's intent was in doing this, and
Like in the upskirting statute?
No.
I'm just.
I hear what you're saying. Here, this amendment was in a direct response to Ramirez, which not only said you can't just do an outright ban, but also told them how to do it, which is treat these like firearms, regulate these like firearms. What did the legislature do besides expanding the definition of what a stun gun was, but simply tack it on to the firearms statute? Part one. And I'll say this. Sure, the direct language of a portion of the statutory scheme is not good for the Commonwealth here. But in view of the entire statutory scheme, you cannot view the entire statutory scheme.
What's the best example that you can point us to where a court has stepped in to the degree that you're asking us to do in order to adjust the meaning of the words used in a statute in a criminal context?
I am relying on maxim and not specifics here.
I'm just asking for a case. I mean, that's what we do here. I have generally tended to be something of a textual literalist during the span of my judicial career, and the only case I can recall where our Supreme Judicial Court has come close to the degree of departure from the plain language of the statute that you're describing is when they took further appellate review on a tax case that I wrote involving Bridgewater State University. But, of course, the tax laws are quite different from the criminal laws. And that was not as strict or as severe a departure as what you're asking us to do.
So, well, I suppose I would say this. You can't hide an elephant in a mouse hole. If the legislature intended to decriminalize an entire class of dangerous weapons by tacking it onto a portion of the statute that was intended to outright ban a particular kind of gun, that is an absurd interpretation of the statute when looking at the scheme, which the court must do, right? And it may be helpful because it is becoming contraptionary, the firearms regulation statute, to remember what this exclusionary clause was for.
Let's say that we were inclined to agree with you Why don't you talk a little bit about the rule of lenity?
So the ruling of lenity applies when there is a plausible interpretation of the statute that creates ambiguity. It is not plausible to interpret this statute in light of the legislative intent to say that it only applies to stun guns that don't look like handguns.
Well, here we don't even have an ambiguity. We have a rather clear statement, and so a defendant who relies on the words does so at his peril?
Well, the defendant also has the benefit of a definition of stun gun that is clear and specific and not tied to the shape of the handgun, but rather how it.
Yeah, but an exclusion that applies exactly to what he has.
Right, with the language that says a stun gun or pistols, revolvers, et cetera, and then an exclusionary clause that can only be interpreted to apply to handguns, short-barreled rifles, these kinds of things.
So stun gun is a weapon, correct?
I agree, stun gun is a
And the exclusionary
weapon.
clause is preceded by weapon.
I agree that, I cannot but agree with that. And I agree that this is well, I would say this. When you use the language, a stun gun or a pistol, revolver, or other weapon, right? And then you then refer to the word weapon, there is at least some indication in the definition itself that stun gun was meant to be seen as distinct from the pistol, revolver, or other weapon. I mean, really, the sum of my argument is this: if the intent of if this court considers the intent of the legislature or reads statutes with the intent of the legislature in mind, and recognizes that it has some obligation to effectuate the intent of the legislature when interpreting statutes, the way that you square this new definition with the clear intent of the legislature, with the definition of stun gun that it added, and with its 131J, the only way to square all of those things at once is to interpret the exclusionary clause to only apply to what it applied to immediately prior to Ramirez. And the argument doesn't get any more complicated or interesting than that. And so, unless there's any other questions.
So that's the absurdity.
Yes, the absurdity is the idea that the legislature, in response to Ramirez, decided to decriminalize a wide swatch of the dangerous weapons that they had just defined as being a stun gun.
You'll be using a new definition of absurdity to the legislature, right? That's not how we apply absurdity. It's absurdity in the result when anyone looks at it and goes, that's what they meant? Not, was a legislature absurd?
I'm relying on Roucoulette for that language, right? I mean, in Roucoulette, I don't know if I'm pronouncing that correctly, but where the language is, you cannot interpret a statute in a way that would be, fanciful or bizarre. And it would be bizarre to make a distinguish stun guns that don't look like handguns from stun guns that do look like handguns.
Well, if I have a keychain that projects a bullet and causes great damage to someone, that's not a firearm, correct?
Correct, but those are.
But if I have a stun gun that doesn't look like a firearm, you're saying that has to be included as a stun gun as a weapon?
Correct. And just to be, part of this is complicated, besides the obvious, but where the exclusionary clause was meant to essentially say, you can never get a license for these things, right?
Well, just for my own, I found that confusing. I wasn't aware of that. Why is it that those devices that are capable of firing a bullet are excluded in the first place?
Thank you, because that's the key point that I'm trying to make here. And it requires some archaeology, right? So first you start with this idea, you can get a license for a firearm, right, which is under the definition, but the firearm statute then goes on to say you can get licenses for firearms, but we will never consider a covert weapon or a weapon that can get through an X-ray machine to be a firearm.
The word that comes to my mind when I hear that is that's absurd.
No, well, It gets better, and the legislature made clear in 131J, or sorry, 131N, that you can never, that even possession these covert weapons.
But that's why they get to make those decisions, and I don't.
But here's the issue. By first of all saying you can never get a license for these covert weapons, and then saying if you even possess these weapons, it is a felony, to get to a point where you think that that is somehow how the legislature decided to decriminalize stun guns, by tacking this, by saying that stun guns that don't look like firearms, by appending the definition of stun gun, this exclusionary language to the definition of stun guns, Part 1, somehow we're also not making it a felony just to simply possess these stun guns. Like, I guess what I'm saying is the exclusionary clause was the tool that the legislature used to outright ban these covert weapons. It's not like they decriminalized, they didn't use those to decriminalize lipstick guns. What they did is use that as a method to say, number one, you can never get a license for these, and if you even possess them, it'd be a firearm. So that's what I suppose I mean by you don't hide an elephant in a mouse hole. You don't decriminalize.
Thank you.
I think that's all. Yes, I am out of time. Thank you very much. Good to see you all.
All right. We move to the third of our criminal matters, case number 2023 P424, the Commonwealth versus James E. Jones. And just as a reminder, we will take a brief recess between the conclusion of this argument and the argument in the following case.
Good morning. Philip Weber representing Mr. Jones. Mr. Jones' case is here today. Two reasons, but I'll start with what I believe is the more significant one, in that the motion for required finding in his case should have been granted. Essentially, there was drugs in this case. That's not in question. Drugs were found in the apartment. There certainly was some type of drug enterprise going on. However, Mr. Jones, there was insufficient evidence to tie him to these drugs for the purposes of convicting him. Now, no actual drugs were found on Mr. Jones himself. As such, the Commonwealth had to proceed either on a theory of constructive possession or on joint venture. But in either regard, there would have been insufficient evidence to tie him to the drugs. Now,
we'll cut to the chase on the constructive possession, plus factors. He's present, so there must be plus factors, correct, to tie him?
Yes, yeah, correct. That is correct.
The big plus factor is the cash.
Right? I would say that is, well, as it's the only thing that the Commonwealth...
There was testimony that those drugs are normally sold cash denominations, normally 20s, or there was some testimony as to the denominations, correct?
Well, the testimony was that it was mostly 20s, although there wasn't specific as to exactly how many, considering that it was a little over $4,000. I mean, I wouldn't expect that to be in ones and fives, just for the basis of, that amount. It was stated that it was mostly 20s. The cash, I would say, is the only thing, but the cash by itself is certainly not enough. I mean, there is cases...
Well, there was other testimony that in enterprises, such as the one that seemed to be occurring here based on surveillance of the building, the group would customarily employ one person as a runner and another person as the person who holds the cash after the transactions are completed, and the person holding the cash stands at the apex. There was testimony to that effect, correct?
I believe so, Your Honor. However, not even all the cash that was found with Mr. Jones. There was cash found, somewhat on Mr. Jones, some was found in different places.
I don't mean to make this personal, but how much cash do you have in your wallet?
I will admit I don't have $4,000.
How much cash do you have in your wallet? Round numbers.
$200 more or less, Your Honor.
Right. I understand that people who don't operate in a digital economy, principally, may carry larger sums. 4,000 is a lot. 4,000 in small bills, where there's testimony that the drugs are packaged and sold in small hits. And there's also testimony about the surveillance of the operation. I mean, I understand that other than the cash, you contend that there wasn't very much, but that's a little bit like the quote of the person asking Mrs. Lincoln of her theatrical review.
And no, I'm certainly aware of that Lincoln quote, Your Honor. However, I would still argue that because ultimately it's just, there's cash and he's around the area. I mean, that could just as easily mean that he was there to buy drugs, which obviously would be an illegal action, but it's certainly not intent to distribute in that regard. Because that's all we have. I mean, the Commonwealth tries to tie in other factors that I would say don't do so at all. I mean, and when you talk about the surveillance, I think it's actually noteworthy that the place was surveilled for, I believe it was around 3 weeks, and Mr. Jones was observed being there twice. So it's not as though he's someone that they've seen there constantly. I mean, that's twice in 3 weeks is certainly not a significant amount of time for him to
Evidence sufficient to support an inference that he lived there.
I think that is debatable because the thing that the Commonwealth tries to point to, and they try to point as being significant, they talk about these pieces of mailings and things that they say belong to him. But I would argue that it doesn't. I mean, the things that were pointed to that supposedly belonged to him had the name of C. James on them.
I'm not talking about the rent receipt. I'm talking about the nature of his presence. I don't remember, was there evidence about articles of clothing in the bedroom where he was found?
I don't recall anything about articles of clothing. The only thing I recall that they would tie to him, because the amount of time he's there, twice in 3 weeks, that's not enough to show that someone lives there. I certainly would say that's, I mean, I've been to plenty of places twice in 3 weeks without living there. And the only other thing, I don't recall any articles of clothing. They point to, you know, the pieces of mailing and other things that they say has his name on it, but the name is C. James and his name is James Jones. Those just, well, they're just not the same name. And it's not, and they try to argue, oh, well, it's James, so that's basically the same thing. But his first name is James, the mailings have the last name listed as James, and James is, it's not exactly as though that's some rare, uncommon name you never come across. I mean, it's James. I think that's a fairly common name, if you, like Smith or Jones.
Concede or share with you my view that is not terribly powerful evidence in my view. That the connection to that rent receipt, or those rent receipts, both temporally but more importantly nominally, is quite limited. But he's there. It's clear that there's a drug distribution business going on, and the cash that he's holding corresponds to a significant role in the drug distribution operation, as described by the expert testimony.
I would argue that I would argue that's insufficient. I mean, there is case law, and I cite to it in my brief, that does talk about that cash simply is not enough. I mean, you have mere presence obviously not enough. Cash is, they have one.
What are the amounts in those other cases?
I apologize.
I think it's 350 or so in CFIS. Is that about right?
CFIS is certainly one of the cases that I do rely on, Your Honor. Thank you. And again, one of the things as well that he was
significantly smaller amounts of cash, and not in denominations that correspond to the distribution operation.
I think the denominations part, I would argue that denominations is not quite as significant. I mean, we're talking about 20s. 20s is perhaps one of the most common denominations. I don't think
except for somebody who's going to be carrying $4,000. They may have 500 in small bills and the remainder in hundreds. But if you're going to be carrying that much cash, I mean, just in terms of the sheer practicality of carrying it around.
Well, I would actually argue otherwise. If someone has cash, they have cash to use it. I mean, that's the reason you carry cash. You his owner to use it. I could say myself, I mean, if any time a person tries to use a $100 bill, most places don't even want to accept that. If you want to have cash to use, it needs to be in denominations that you're going to be able to use. So $20 bills is actually not the most unusual thing in terms of denominations to be able to carry.
On your person, $4,000.
It's a large.
That's just not CFIUS.
I acknowledge that it's a large amount. I'm certainly not stating otherwise. I mean, if I were coming into this case as a financial advisor, I'd probably tell him to do something different with his money.
If he were stopped on the street, walking in a park with no other indicia of drug distribution, it would be curious, but not obviously criminal. But in the building where they have determined a high likelihood of drug distribution based on controlled buys, based on their observations of interactions consistent with drug purchases, over a long period of time, that amount of cash on his person, coupled with a smaller amount, in fact, in a drawer in the bedroom where he was found, $1,200 if I remember correctly, that's hard to explain.
Well, actually, I would point to some of the things in the investigation, if anything, would lead that he is not involved with it, because there was one bedroom, bedroom one, which is basically determined to be kind of the epicenter, the centerpiece of everything, and that's not even a disputed fact. I believe the Commonwealth.
Oh, the storeroom, the inventory.
The inventory, there was some cash in there as well, multiple things, but that was a locked room that Mr. Jones didn't even have access to. He didn't have a key to it. He didn't have an ability to access that room. So the idea that
but can I interrupt for a moment?
Oh, certainly.
I feel like the most helpful thing, being selfish for me, would be for you to kind of agree with the standard, right, of sufficiency, and to tell me with the facts which are not in dispute, right? Seen outside by surveillance twice. On the time that the search warrant was executed, he's present, his car is there. He's got $4,000 in small bills and C. James with the rent receipt. That's kind of the universe I'm living in, with the light most favorable to the Commonwealth. Why is that not enough? So you answered to the chief respectfully, well, it's debatable. Debatable doesn't win your case.
Well,
because I've got the, right, I look at the standard. So given those facts, given this is the universe, C. James rent receipts. He's present, he's got $4,000 in cash, he was seen there twice outside, his car is parked there. Tell me why that's not enough for constructive possession.
I would say it's not enough for constructive possession because ultimately he doesn't have access to he doesn't even have access to the main epicenter of it, because even though the Lattimore standard certainly puts inferences in favor of the Commonwealth, it all has to add up. It all has to make sense. That is one of the ideas behind this, that if it doesn't add up and make sense, then we don't have enough here. So if the idea is supposed to be, well, he's the guy who's carrying the money, but at the same time, he doesn't even have access to the room that has everything of significance in it. I mean, I think that is actually a quite a significant factor, that how is they would trust him enough to carry the drug money, but they don't trust him enough to have access to the room where the drugs and other important things for this drug enterprise are kept. I mean, I think those two things alone conflict at a fairly significant level, because it just simply doesn't add up. It doesn't make sense. He doesn't have, I mean, because there is all the lack of factors as well, because ultimately at the end of the day, you just have money on him. And we have to have, if we have conflicting inferences that could be equally likely in different directions, then that's not enough for a required finding. Drugs, money on him.
Just on that point, we hear that a lot. When is the last time that principle has been applied to reverse a conviction on sufficiency?
Apologize, Your Honor, that I don't have a site to know the last time that would have been referred to, but it is.
It's been a long time. I don't remember one during my time.
Well, Your Honor, I mean, I apologize.
And the words are
but
out
it is still, I mean, I still cite to it as it is still applicable law, so it
you
certainly is still something that I.
Why we hear it a lot.
And with this one, I mean, ultimately because if the mere presence was enough, even with the fact there's hashtag, I mean, there were other people that the police didn't even bother to keep there. I mean, because when they do the arrest, we have Mr. Jones, we have his two co-defendants, and then there's two other random people that they just don't even bother to arrest and let them go. So this idea, it really seems more than anything else that they were targeting.
They have $4,000 in cash?
There was nothing in the record indicates what was on their person. Since they weren't arrested, it appears that they probably weren't even, that they probably weren't searched would be the most likely scenario. So it's unknown in that regard.
Now, so let's say we granted you that he did not have the ability or the intent to control the drugs. Under a joint venture theory, as a money man, would he thus be liable?
I mean, if he was in fact the money man, if he was the money man for a drug enterprise, then that would be enough. But, you know,
So constructive possession isn't the only avenue?
It would be constructive possession or joint venture. Constructive possession is not the only way that he could be convicted of intent to distribute. That is correct, Your Honor.
And the other issue, what is your opinion of the other evidence? We'll hear from the Commonwealth, though. There was a police scanner, there were scales. Is your position, in light most favorable, he didn't see those items, that they were concealed from him? Or or they're innocuous items, or something different?
Well, it's not so much innocuous. I think that there's certainly a significant amount of evidence to show that there was some drug enterprise going on. And Mr. Jones may have very well been aware of it. But I think it doesn't matter at the end if he's aware of it, because knowledge is not enough. Just he could know that there was a drug enterprise going on. He could hang out with people doing drug enterprise. And sure, maybe you should pick your friends better, but you hanging out and being around the area would not be sufficient. So even if he has full knowledge of everything going on, that would not be sufficient in order for him to be convicted of intent to distribute, as he would have to have, and I cite to the cases in my brief, but there's certainly a multitude of cases that talk about the fact that being aware is not enough. You have to be actively participating within it. So under the Lattimore standard, I think it probably could be found that he had awareness of it, but that's stated, not the deciding factor. While I do believe that the motion for required finding is the most significant one, I do want to just briefly at least address the other issue, and that the motion to sever in this case should have been granted. And that is because really the only reasonable defense that Mr. Jones could have possibly mounted in this case would be to blame his other two co-defendants. Because as stated, there's no question that there was some kind of drug enterprise going on here, some kind of
attempt to do that?
I feel as though he implied it, because he didn't flat out state it, and I think that was actually part of a strategy as well, because he doesn't have to blame necessarily both of them. The idea is that it had to be at least one of the other two people. So if he specifically states it's this co-defendant as opposed to the other one, well then all of a sudden you put all your eggs in one basket, you're saying it's one person opposed to the other.
I understand that would be the approach that you would adopt, but I mean, I don't know that he was foreclosed from doing it, or that it certainly doesn't appear that anyone tried to blame him.
Well, they may have not tried to blame him because there's such a scant amount of evidence that ties him to it that I don't think it would make as much sense for them to blame him. But I think also the fact if the motions ever been granted, perhaps he would have been more open about blaming them. But it's kind of
what about the joint trial precluded him from making that defense?
I think it would put him in a difficult situation because he's already in a place where these are his co-defendants. The jury's already tying the two people together, and then all of a sudden we have the situation where he's blaming someone else, because it's the only.
Okay, I see that your time.
So I'll rest on my brief.
Thank you.
Thank you.
For the Commonwealth.
Ann Kennedy, Assistant District Attorney for the Middle District. Good morning, Your Honors. This court should affirm the defendant's convictions for possession with intent to distribute heroin and cocaine. When viewed in a light most favorable to the Commonwealth, the evidence was sufficient to show that the defendant did possess both heroin and cocaine with the intent to distribute it. I think it's also important to note here that this was a bench trial, not a jury trial. And one of the reasons why I want to note that it really pertains to the second issue, which this court should also agree that the defendant's conviction should be affirmed for, which is that the motion judge did not abuse his discretion when he did not sever the cases. Given that this was a bench trial, not a jury trial, and the judge, who was the fact finder, could easily have readily discerned the difference between a defendant blaming other defendants and determining the use of that potential evidence. So unlike what my brother had indicated, that you might not want to present that in front of a jury, this was in front of a judge. And so I just wanted to address that one particular piece.
On the plus factors, I'll just give you an opportunity to respond to the skepticism I voiced earlier about your attempt to attach this defendant to the rent receipts.
Well, when you look at the evidence, again, light most favorable to the Commonwealth, all reasonable inferences in fairness go towards the Commonwealth, and the rent receipts were not mailings. They were just little slip receipts that said C. James on them.
Right.
The defendant in this case, of the defendants that were connected to this apartment, was the only one with the name James.
His first name was James. C. Yes. James suggests James as a surname in that instance. They were dated several months prior to the onset of surveillance here. Suppose they had, it's hard for me to see that as was there any evidence that this defendant used C. James as an alias?
No, Your Honor, there was...
Any evidence that he ever signed any documents using the first initial C?
No, Your Honor, there was not. But
Does
the question
his middle initial is?
E.
E. So James E. Jones, C. James, 6 months earlier at the most recent, a year earlier as to the several other weekly rent payments.
Yes. But again, the question, Your Honor, isn't, if that was the only thing tying him
I
to the
understand
apartment,
that.
I would not
even in
be
the light most
standing
favorable
here.
to the Commonwealth, I don't see that as
A reasonable
something
inference?
that a jury could rationally accept as a point of connection to this defendant.
I am going to disagree with you on that.
We can disagree.
Obviously, it's your decision.
Right.
But with respect to that, when you connect that with the other aspects of the case, you can't just take that in and of itself alone. You have to connect it to the fact that during that 3-month surveillance, he was seen at the apartment at least twice. There was no testimony that it was only 2 times that he was seen there. I think it's important to distinguish this. The testimony was that he was seen there at least 2 times. In fact, his counsel asked Trooper Dolan on cross-examination if the only time he saw the defendant at that apartment were the 2 times were when those pictures were taken. And Trooper Dolan said no. If you take that in context, he was seen there at least twice. It doesn't mean only twice. And that was prior to the execution of the warrant.
Can I back up for a moment, though? Sorry, for clarity. Can we just go back to the rent receipts for a moment?
Sure.
Part of your argument about, given the standard, is that of all the people charged, this was the only James, right?
Yes.
What I don't have clarity is were the other rent receipts found for the other individuals, and it was C. Mark and C. Bobby and C.
Your Honor, one said Vincent Mortel, and the other defendant's name was Vincent Mitchell. So there was 5 rent receipts in total, and those are in the appendix. One was read as saying Vincent Mortel, and the other 4 were read as C. James.
So of all the occupants, we have 2 potentially somewhat matching, but not accurate.
Not
that you're drawing the inference.
Yes, Your Honor, not fully accurate, but again, when you're considering that in the context of everything else, I think it is a reasonable inference that the trial judge could have made as the fact finder that those rent receipts were connected to the defendant.
Thank you.
Other plus factors that this court has already emphasized was the amount of money found on the defendant. I did want to clarify that there was a bag of money found in the room that he was in. It was not in a drawer. It was in a medical bag, and it was over $1,900. That was found in the bedroom that the defendant was found in. Additionally, there was expert testimony with respect to the person's role as the money person in the case. And given that he had all the money in his possession with respect to those significant amounts. There was some money found in the bureau. There is no indication as to how much. The defendant, McCloy, who was found on the premises, had no money on him. So that really comported with the expert testimony that explained how drug distribution operations of this type occur. So given all of the information that was present before the trial judge, and given the Lattimore standard, and a light most favorable to the Commonwealth, the evidence was sufficient to convict the defendant.
You would concede, or would you, that the defendant played a subordinate role to a co-defendant in this case?
No. I would not,
The co-defendant whose fingerprints were found on the safe in bedroom 1, where all the drugs, money, and guns were found, there was only one co-defendant's fingerprints found on the safe, correct?
yes, Your Honor.
His name was on the television,
Yes, Vincent.
Vincent. And you don't think that access to that clear or circumstantial evidence that he was in that bedroom makes him more of a primary target than the defendant?
No, and the reason why I don't, and if you look at the testimony of the expert, the person who's the money man who, as Justice Green had said, was at the apex of this, is usually the person who tries to divorce themselves as much as possible from the drugs. But if they're the ones holding the money, they're the ones in charge. So that's why, based upon this evidence, I would argue that the defendant in this case was not the subordinate, but in fact in charge of the operations. If there are no further questions with respect to that issue or any issue, the Commonwealth will rest on its brief.
Seeing none, thank you for your arguments. The case is submitted. We will take a very brief recess. We will resume the session at 11 o'clock.
Court is open. Please be seated.
We resume our session with the first of the three criminal matters we have on the hearing list this morning, case number 2022 P1221. This is a case involving the termination of parental rights. The case is impounded. The argument in this case, as all of our cases, is open to the public. We are streaming live and archived on our YouTube channel. And I say that just to remind counsel to refrain from mentioning any of the parties' names, refer to them by their role in the case, mother, father, child, etc. You may begin.
Good morning. May it please the court, I'm Lily Lockhart on behalf of the appellant father. I would like to start by addressing 3 points from the appellee briefs. First, father is not challenging his unavailability, rather he is challenging the termination of parental rights. Second, in the department's brief, they argue that the issue was not preserved below, and that is not accurate. Father did file a motion with the court saying that the department had not made reasonable efforts in bringing the issues of paternity testing to the court's attention, and I'll discuss this in more detail. Third, the child argues that father is requesting a de novo review. Father's not making that argument, but rather he's arguing that the judge erred in finding that the department had made reasonable efforts. The judge's conclusion in this case that the department had made reasonable efforts with father was unsupported by the evidence. The court's findings were inconsistent. The trial court found the department had made reasonable efforts and provided services, but wrote in his findings that the department had never visited with father and could have done more to meet with father. And in fact, there were at least 3 or 4 separate occasions where both father and the social worker were in person at the courthouse, and the social worker failed to meet with him even in those occasions. Further, the judge erroneously...
Let me interrupt for a moment. I mean, it's okay for a judge to say, no, you could have done more, but it's enough, right? I mean, in essence, when I read the detailed findings, while probably in most cases more could be done, the judge also took into consideration a number of issues. I want to get back to what I think is a very important part that I want to hear your argument. I mean, there was a motion, undeniably so, but it wasn't for the reasonable accommodations. It was titled that, but it was really so that the parent could potentially take the child in. And the judge didn't close off the possibility that the right motion could be filed if really the purpose of the request was really what it was. So can you address the issue of waiver? Because just because you call it something doesn't mean that it preserves your right when the substance of the argument doesn't match what the motion is, right?
Yes, Your Honor. So the caption of the motion was reasonable efforts, but the crux of the motion, while the remedy that father was looking for was a consideration of placement with his mother, the crux of the motion was proceeding with the paternity testing. And at that December hearing, there was lengthy discussion with the judge about the delays in paternity testing, how the order had been issued almost a year beforehand, how nobody could understand why the paternity testing hadn't proceeded, and how basically everything in the case, as far as fathers was concerned, was being held up because the paternity testing had not gone forward. They came back in February and there was a report that, okay, now the Department of Revenue is aware of the order and they are going to begin the testing, but it still hadn't proceeded. So it did.
But to Judge Walsh's point, there was never a motion made requesting involvement by the department other than to get the testing, not to take this, that, or the other thing in terms of reasonable efforts to address the, and I think it's important to set the stage starting a little earlier than any of that, because this child was removed from the mother's custody at birth because of the father's rather severe physical abuse of an older sibling for which the father was incarcerated, and that had a significant adverse effect on his availability for any efforts of any kind.
Yes, Your Honor.
It
So
goes both to his fitness and to his complaint that he wasn't given an adequate opportunity because the impediments to that opportunity were, with all due respect, largely of his making.
Well, Your Honor, I do want to respectfully say that he was being held pre-trial, and I think that his carry, which was admitted to evidence, would reflect that. So during that period of time, yes, he was incarcerated, but he was only charged. He was not convicted of that crime. So in some ways, that is out of his control. As the record reflects also, for the first...
Well, not out of his control. It's outside of our record, but it's a matter of judicial notice. What was the eventual disposition of those criminal charges?
He was found not guilty.
By a jury?
By a jury. Yes, Your Honor. Mother did not disclose the identity of who she believed the father was, and she denied that father was the father up until November of 2020. So father wasn't even appointed counsel until September of 2020. So while there is some documentation about communications between him and the department early on, at that point in time, the information that he had was that he was not this child's father. Once he was appointed counsel and once mother came forward almost a year later saying, yes, this man is the child's father, he, through counsel, immediately proceeded with filing a paternity action and trying to seek paternity testing as quickly as possible. So, father on his end did what he could to try to proceed with that. And, going back to father's motion regarding reasonable efforts, I think that he and his attorney's assessment was that the paternity testing was a threshold issue. The department was essentially saying, we're not going to offer visits, we're not going to look at family members if he's not the father. So that needs to be completed before anything else. So I think the focus of the conversation was on paternity testing, and unfortunately that did take approximately 15 months to complete before he was adjudicated, and that ended up happening on the day of trial.
But that's in a vacuum, right? I mean, it from the very get-go, despite mother denying who the father was, father denied as well, called from some phone that couldn't be traced, right, and said the child isn't mine. And then despite any efforts, not in person because of COVID, but by contact from the department. So I find it, I still want to hear about why it isn't waived when it's called reasonable efforts. He's not looking for reasonable efforts. He's looking to have paternity determined so that his parents can maybe take the child, maybe. So he didn't file a valid reasonable efforts is how I see the judge's ruling. Refile it. Tell me what the reasonable efforts that you're requesting, defendant, not, this is filed so that child can live with grandparents.
So I think, and additionally, a trial father called into question through cross-examination of the social worker, issues around the social worker not exploring services that father would have been able to access, not attempting to visit him at the jail, not exploring whether or not she could do a Zoom call with him, not meeting with him at the courthouse to review his action plan, not arranging visitation for him because he wasn't the legal father. So those were all of the things. I mean, I think, he wasn't going to request custody to himself when he was incarcerated. And he was aware of the obvious limitations of that situation. So he was putting forward his mother, but his effort was to be able to reunify with his child and for his child to be placed with family during the time that he was incarcerated.
So besides the merit to the argument about reasonable efforts, which is, I'm trying to be a parent. Department, you have an obligation if I'm trying to be a parent to do things, and yet I'm pre-trial, I don't have services, it's COVID, etc. That's the merits of the argument. The legal part of waiver is you got to put something before a judge that says what it is, or it's waived.
And, I think, Your Honor, looking at, granted, Father's motion on reasonable efforts was a fairly brief motion. It just kind of cites that the department wasn't making reasonable efforts as far as the paternity testing and exploring the paternal grandmother. But if the court looks at the transcripts from the December hearing and then the subsequent February hearing on that reasonable efforts motion, I think there is more lengthy discussion, and there is a back and forth conversation between Father's counsel and the judge about, what obligation does DCF have in this, because, DCF can't conduct genetic marker testing, and there is conversation that, the Department of Children and Families does still, even though they can't do the testing themselves, that's the Department of Revenue, they do still, I think the judge says, they still have an obligation to find solutions for the children in their care. And this child was in their care and didn't have an identified father, and they had a gentleman standing there saying, I think that I might be this child's father, and I'm trying to pursue paternity testing and get involved. And DCF was doing nothing to assist in that process. They weren't following up with the Department of Revenue. They weren't meeting with him. So I think these things were discussed at the hearing, and I think that is reflected in the transcripts. And I think that the issue is preserved because of that, because it was brought to DCF's attention and it was brought to the judge's attention back in December of 2021 through those hearings. So, Your Honor, the judge also erroneously found that Father did not do enough, but Father did make timely efforts to establish paternity once he found out that Mother was saying that she believed he was the father. And his failure to do more doesn't absolve the department of their responsibilities. The appellees reference adoption of Mario as a case for the proposition that the parent has an affirmative obligation. But if the court looks at that case, that was a situation where the mother was actually taking actions that prevented services from occurring. Whereas this is more of a case where the judge faulted Father for not doing more, for not writing letters to the social worker, for not, more affirmatively requesting visitation, even though DCF was saying they wouldn't offer it because he wasn't adjudicated the father as of yet.
Judge says that the father has never met the child and vice versa. Is that correct?
That is correct, Your Honor, to my understanding based on the record, yes.
The father denied paternity until
Initially.
It was established. Right. And after paternity was established, what efforts did Father undertake to meet the child?
Your Honor, Father's rights were terminated on the day that he was adjudicated the father. May 24th, 2022, they appear for trial. He's adjudicated that morning. Rights are terminated that day. He had a period of maybe 5 hours of legally being this child's father. So
when did he, okay, let me rephrase the question. From the point where he stopped denying paternity until paternity was established, was there any gap in time? Was there any overlap?
Yes, Your Honor. So yes, Mother identified that she believed he was the father in November of 2020.
Did he accept that suggestion? Or
He wanted
deny?
to seek genetic marker testing, given the inconsistency in Mother's statements. And
So from that point forward, what efforts did he make to develop a relationship to meet the child, to become involved as a father?
I mean, at that point in time, Your Honor, he was very severely limited because he was held.
I know he was limited. What efforts did he make?
Your Honor, I think his efforts were through counsel to establish paternity. I would have to concede that there aren't further efforts in the record, but DCF was also very clear that they weren't going to offer him visitation until and unless he was adjudicated the father. And the DNA testing didn't come back until, I think DCF, the testimony was that they had the testing in hand less than a month before the day of trial.
Under the terms of DCF's, of the department's involvement, was the mother prohibited from bringing the child to the facility where he was housed?
The mother didn't have the child.
I'm sorry.
DCF.
I'm sorry. Of course. All right. I don't know if there are further questions or if there's anything more that you would like to say to us.
No, just in closing, Your Honor, the department's failure to make any efforts at all to work with Father deprived the child of her fundamental rights to have a relationship with her father and really with her entire paternal family. So father is asking that the court vacate the decree and remand the matter so that he can have an opportunity to engage in services, visit with his daughter, and establish a relationship between her and also between her and her paternal family. Thank you.
Thank you. I understand that the department will argue for 10 minutes, and then we will hear from counsel for the child for 5.
That's correct, Your Honor.
10 minutes.
May it please the court.
Clock.
Yes, sir. Almost there.
Just bear with me for a moment.
And we're there. Good morning, Your Honors. Samuel Ferguson, Assistant Attorney General on behalf of the department. Father is seeking to overturn the juvenile court's termination of rights decision in the face of an undisputed history of physical abuse of children in his household. That included kicking daughter M into a space heater, injuring her in her leg and causing her a black eye, and also beating her repeatedly. And most significantly, a few months before the birth of child, father inflicted horrific, life-threatening injuries on then 3-year-old Jay that led to surgery.
You say that, but as we've heard, he was acquitted of that charge?
Your Honor, at the time, first of all, the father does not dispute the findings of the lower court, and the findings of the court are not determinative based on a criminal standard, but on another standard.
Preponderance standard, there was enough evidence to support the...
Yes, Your Honor. And again, most significantly, these findings are not disputed. So whatever the jury may find on that basis, in terms of...
I understand, not to place too much emphasis on it, but I did notice that the juvenile court judge in her memorandum of decision made the statement that the factor, the statutory factor that says that a conviction should be applied in determining termination applies here, but and she explained that by reference to the father's pretrial incarceration. Strictly speaking, that would be a legal error, wouldn't it?
Yes, Your Honor. It would be a harmless legal error because a conviction isn't required under the circumstances, particularly, again, when the abuse was not disputed. And it was so severe and repeated in 2 separate households in which the father had been present that the judge properly made the determination that the father was unfit. And indeed, the father didn't dispute that he was unfit. And so the only real issue with regard to termination is whether that unfitness was likely to continue into the future. And based on the evidence, it was obvious to the court that it would because of his repeated, undisputed incidents of severe physical abuse, his unavailability at the time, and his complete disinterest in the child. The father, as the court noted, never saw the child. The father was not incarcerated until 3 months after the birth of the child, did not see the child at all during that time. For a year, the father disputed and denied paternity. In fact, father's only contact with the department was to deny paternity. And it was only when father retained counsel that there was an effort to establish paternity. But again, I shouldn't use the word establish, I would say determine, because it isn't clear whether the father was asserting paternity or whether the father was attempting to definitively determine whether or not he was indeed the father. And all his other actions point in the other direction. His complete lack of contact, his failure to make any effort whatsoever to contact the department to gain any kind of services whatsoever. Whatever the failings of the department may have been in providing services for father, there is no dispute that he was sent information from the department with an action plan. That plan included, on at least 2 occasions, a contact number for a caseworker at the department that father could contact. He never did, never attempted to do so. And when one looks at the reasonable efforts defense or counterattack by the plaintiffs here, the Mario case does, and other case law as well, points out, there's got to be at least some sign that a parent is seeking services before they can raise the issue of the department's failure to take reasonable efforts. And here, there were no such efforts to do so. There was a motion, as the court pointed out, that was labeled seeking reasonable efforts, but the reasonable efforts were only for the purpose of determining paternity and in that case, and if it was affirmative, to place custody of the child temporarily with his parent. There was no effort to get services or visitation in the event that a paternity finding was successful. So there's absolutely no indication at any point throughout these proceedings that the father sought any contact whatsoever with the child. And that alone is a reason enough for the court's finding that reasonable services argument was waived. Sorry, that wasn't a finding of the court, our argument, but the court found that it didn't hold water. And to the extent that indeed the department could have done more, the court found that the father did less and in fact did zero. And in the face of the absence of any effort, the reasonable efforts argument should not be sustained. And perhaps more importantly, under Chapter 119, Section 29C, reasonable efforts argument is not, does not preclude a finding of unsuitability and termination. And in this case, that is very much, this is kind of a classic case of why that is so. And indeed, one of the exceptions to the requirement of a department taking reasonable efforts to reunify the family is if children in the household have been subjected to severe or frequent abuse. And that was a finding of the court in this case. So that even under the law, under Chapter 119, 29C, there was no requirement in this particular case that the department take reasonable efforts. Nevertheless, the judge found that the department did so, but it was hamstrung by the circumstances of the pandemic itself, by the lack of communication from the father, and the father's unavailability. And again, it's true, and the court, lower court noted, that the department could have done more, but that is not the same as saying that the efforts it did take were unreasonable or were insufficient under these particular circumstances. So we have a situation where the father, first of all, waived his rights by not seeking services from the department, where the court properly made a negative inference because of the father's failure to testify at the hearing despite his presence in the courtroom, where the children were subjected to repeated physical abuse in the household, and where, in the absence of a paternity finding, and I should have mentioned this earlier, there was no obligation on the department to take reasonable efforts because it wasn't clear whether this person was indeed the father, particularly where this person denied that he was the father for over a year beforehand, and where the mother also denied that he was the father. So that collection of circumstances, plus the fact that the overriding consideration of the court was what is in the best interest of the child at this point, all pointed in one direction. And that decision was bolstered by the fact that the child was in a pre-adoptive home where the child was in fact thriving. I will leave it to my brother to update the court if it wishes to hear the current status of the child. But the father had never seen the child. The only adults the child was bonding with was with the pre-adoptive family. And it would be severely detrimental for the child to be in a position of limbo with the possibility of an attempt at reunification with an abusive parent. So under those circumstances, the court acted properly and the decision should not be overturned. Unless the court has any further questions, I'll leave it to my brother to continue.
Thank you.
Good morning, Your Honors, and may it please the Court. My name is Sean Grammel. I'm from Anderson and Krieger, and I represent the appellee child. She asks that you affirm the termination decree so she can be freed for adoption. I agree with everything that my brother just argued, so I'll touch on 2 points quickly, 2 arguments that father makes. The first is on the lack of reasonable efforts, and the second is on the lack of enough time after he was adjudicated father to work with DCF. So first, I agree that father did not identify any actual services that he wanted from DCF for reasonable efforts. DCF does not do genetic marker testing. They did all that they could here. They talked to the Department of Revenue, they sent that, and they waited just like everyone else. Father could have followed up with DOR. In fact, it's his obligation to establish paternity. It's not DCF's obligation to make sure that he is in fact the father. He does mention visits. Again, he never asked for them. He concedes in his brief at page 19 that he had no right to them. And I understand that it would have been difficult while he was incarcerated to establish visitation with the child. He could have picked up the phone. He could have called the social worker. He could have done something to establish some kind of a connection with this child. He could have asked for updates. He could have asked for a picture. He could have sent something. There's no evidence in the record that for the 2 years of this case that this father did absolutely anything to establish any kind of connection with the child. So under all of these circumstances, that's why it's not clearly erroneous for the judge to decide that the efforts were reasonable. My sister referenced adoption of Mario, which I do cite in my brief. The things that the mother did in adoption of Mario that frustrated DCF's efforts were go to prison and never contact DCF. Both of those things are present in this case as well. Putting all of that aside, as my brother mentioned, even if the department made 0 efforts, if they did things that even inhibited the relationship, lack of reasonable efforts is not a defense to termination. That's the last sentence of Chapter 119, Section 29C, and then it's picked up by adoption of Alona all the way through adoption of West. Under 29C, the focus is on the best interest of the child. And here, father does not dispute that it was any abuse of discretion for the judge to find that her best interests were served by adoption by the only family that she's ever known. So that goes to reasonable efforts. Father's second argument is about having more time after he was adjudicated the father. This argument essentially boils down to a request that the child live in foster care without permanency for some indefinite amount of time so father can do some uncertain services in the hopes that one day he could provide a safe, stable environment for the child. And the father needs to show this was an abuse of discretion for the judge to reject. There's no evidence in the record, none, that father would be in any position anytime soon, as of the time of trial, to provide a safe, stable home for this child. If father wanted his mother to be the placement option, he could have done that at trial. He could have put paternal grandmother up as the alternative adoption plan, guardianship plan, permanent custodian. He didn't do that, and he didn't even testify at trial. So any complaints about paternal family not being involved were waived down below. So for all of those reasons, Your Honor, my client requests that you affirm the termination decree and free her for adoption. And if there are no questions, I will rest on my brief.
Your client recently turned 4?
Yes, she did.
And when you say she's requesting, that's literally she's telling you that, or is it substituted?
This is a substituted judgment. I can explain why I came to that decision, but I think the record reflects the very serious abuse of 2 children by father, one of whom was 3 and one of whom was 5. So she's right in that window of age range that father has inflicted horrific abuse on, so she would like to be adopted by her family. Thank you.
Thank you. Our next case is case number 2023 P504, Charles D. Clarke versus Donna M. Murphy.
Can I just start? Good morning, Your Honors, and may it please the Court. I am Donna Murphy, the appellant in this case. I was a defendant in the originating case, and I am here pro se. I am asking this Court to reverse the rulings in this case and to assign to plaintiff all legal fees, including the cost of the receivership that the trial judge ordered, and since the submittal of this appeal has not been stayed by this Court. I submit that the decisions in this case should be reversed for 3 reasons. 1, the Court has failed to correctly apply the law of guarantee. 2, the Court has failed to interpret the words of the contracts involved in their plain and ordinary sense. And 3, the Court has made rulings that are unsupported by evidence and the Court's own rulings. Almost 6 years ago, plaintiff initiated this lawsuit asserting without evidence or substantiation that he owns my beneficial interest in the 158 Adams Realty Trust, which I will hereafter refer to as the trust. Error has piled on error in this case, starting with the misapprehension of nominee trusts, exacerbated by a failure to properly apply the law of guarantee, and culminating with a verdict that is inconsistent with the terms of the parties' contracts and the Court's own findings. Please allow me to correct one issue that I did not directly address in my reply brief, and which could be material to your decision-making. Plaintiff asserted in his brief that I drafted the partnership agreement, and that any ambiguity in the contract should thus be construed against me. However, plaintiff in his deposition testimony stated that the testimony was, quote-unquote, banged out by him and me, and that I put it in written format. That's in Record Appendix 4, page 135. Plaintiff then contradicted his deposition testimony in his affidavit when he stated in paragraph 7 of his affidavit that he believed that I drafted the agreement based on his review of the properties of a Microsoft Word document that he personally examined. There's no evidence in this case to support the assertion that I drafted the partnership agreement. I did not draft
The judge's decision on this principal question doesn't turn on interpreting the contract based on who drafted it, right?
Correct.
So let's, I appreciate that clarification, but am I correct that the plaintiff signed the note?
Yes, you are.
So he was directly liable on the note without any defenses that might otherwise be available to a third-party guarantor?
Yes.
In those circumstances, why is an independent, separate guarantee not entirely superfluous to the obligation undertaken on the note?
So in the case that I noted in my brief, which I believe is SKW v. Gold, they addressed that point directly, which is that in the case of a note particularly, a signer on a note has certain defenses that are not available to a guarantor, particularly that a guarantor does not have a right to notice, which a signer does. So that has been directly...
Is there any aspect of the relationship or I understand that this business was successful for a while and then ultimately ran into more difficult times. But the note was paid in full, correct?
Excuse me, Your Honor. So there's many businesses here, so if you could specifically say which business you're talking about.
Well, I mean, I understand the real property was largely a huge success. It tripled in value and was not and was that's the main event for liquidation and distribution of proceeds, and that's what you're fighting about. But the catering business was successful for a time and then not.
So plaintiff's catering business, when he ran it by himself, was very successful, and when he ran it as a partnership with me, was not able to earn enough money to pay the rent.
Well, that's something of a sideshow. My point is that the obligation represented by the note and that would have been the subject of the guarantee was satisfied in full without incident, correct?
I'm sorry, repeat the question, Your Honor.
The obligation represented by the note and that would have been the subject of the guarantee was satisfied in full without adverse incident.
It was.
So I'm trying to understand the materiality, the consequence, the effect of the absence of a guarantee in any practical, meaningful sense.
Okay, so the plaintiff's ability to accrue equity through the payment of rent was conditioned on guarantees of the note, the mortgage, and the lease. Plaintiff breached...
I understand. So what you're trying to do is say that he did everything that of financial substance that the agreement called for, but because he's only signed as a direct obligor on the note and didn't sign an independent guarantee on a note that was satisfied in full, should preclude his acquisition of the the equitable share of the property that the parties agreed to.
No, Your Honor. Plaintiff also breached his guarantee of the lease. The guarantee of the lease, the note, and the mortgage were the preconditions.
A guarantee does not impose obligations on the guarantor that exceed those on the underlying obligation, correct?
Correct.
Okay. And if that underlying obligation is modified in a manner favorable to the obligors, the guarantor is not bound by the original obligations prior to that modification.
So you're getting ahead of yourself. Excuse me, Your Honor. The plaintiff guaranteed...
Sorry, that's the way my mind works.
I'm sorry. The plaintiff guaranteed the lease.
Yeah.
He guaranteed all the terms and conditions of the lease.
Right.
So one of the terms and conditions of the lease was the lease could not be more modified unless in writing. And another condition of the lease was that silence could not be construed as waiver. Those terms
Once
were
the lease
guaranteed.
was validly modified by the direct parties to the lease, the guarantor's obligations on the guarantee cannot exceed those on the underlying obligation.
I don't believe that's true. I believe...
What case do you have to suggest that it's not?
So as identified in my brief, the plaintiff is responsible specifically for the terms of the lease. So
I'm asking you a different question. I'm not asking you what the guarantee says. I'm not asking you what the lease said. I'm not asking you for a number of words that can lead to the conclusion you're asking us. I'm asking you for a case that stands for the proposition that a guarantor can be liable for obligations under an instrument that exceeds the terms of that instrument as they are subsequently modified.
Cedar Fields, it's in my brief, which specifically says if the underlying terms of the lease have been modified, the obligations of the guarantor are unchanged. It's in my brief.
Those, the obligations of the lease in that case were reduced or expanded?
Reduced.
I'll take a look at that case.
I should continue?
Please.
The motion judge erred when he found the plaintiff fulfilled his obligation to guarantee a certain note and mortgage by signing the note itself. I think we've addressed that. So the statute of frauds requires a guarantee to be in writing. This case amply demonstrates the importance of the statutes of frauds with respect to guarantee. A person can be both a primary obligor and a guarantor. In this case, Clarke was a primary obligor. He was not a guarantor. He did sign a guarantee of a lease, which was also a precondition to earning the equity. Both the motion and the trial judges, however, in ruling whether plaintiff breached his guarantee of that lease, focused only on the lease obligation and failed to recognize the guarantee contract at all. In ruling against me on the count of breach of guarantee, both judges pierced the lessee's corporate veil to find plaintiff not liable for the terms of the lease that he had guaranteed. However, that issue wasn't before the court. The issue before the court was plaintiff's breach of his guarantee of that lease. This appeals court has ruled that a guarantor's liability is dictated exclusively by the express terms of his written guarantee. Under the terms of his written guarantee, plaintiff guaranteed all the terms and conditions of the lease. As correctly recognized by the motion judge, the lease states that the lease terms could only be modified in writing. Thus, plaintiff both guaranteed that any modification to the lease would have to be in writing and asserted that the parties had orally modified the lease. Plaintiff both guaranteed that silence would not be construed as waiver and asserted the defense that silence constitutes waiver. Both the motion and the trial judges failed to discern the irony. They both failed to acknowledge the terms of the guarantee contract at all. There's no dispute that plaintiff did not ensure the payment of rent as required by paragraph 3 of the leaseity guarantee, that plaintiff did not ensure the payment of taxes as required by 3B of the leaseity guarantee, that plaintiff did not ensure the payment of water and electric, and did not ensure that his company installed its own water meter as required by 4A of the leaseity guaranteed. Plaintiff did not ensure the payment of the company's share of sewer bills as required by 4B of the leaseity guaranteed. He also failed to honor the terms governing trade fixtures and the treatment of equipment left on the premises at the termination of the lease.
Mr. Murphy, for what period did the plaintiff not pay the lease? Was it not responsible for?
I'm sorry, repeat the question, Your
For
Honor?
how many months or for what period do you believe?
So for water, it would have been, for both of them, it was for almost the entire extent of the lease. But for water and sewer, he paid twice in like 2005 and 2006. I'm doing that from memory.
I don't mean the services, I mean the mortgage.
There was no issue with the mortgage, Your Honor.
Or the lease.
The lease. So he failed to pay rent for the months of January, February, and March of 2014.
And you were reimbursed for that, correct?
I think that's, again, it continues to be a confusion about me being reimbursed. The lease was between CCI and the trust.
Trust.
The trust, excuse me.
Yeah, the trust received payment for those, there was no non-payment of rent at the end of the day.
There was a non-payment of rent. The rent was not paid. The trust subsequently dispersed money to me, but the rent was not paid. The rent was not paid, period. And there's no dispute about that.
Okay. So why would that not be a charge to the tenant side of the ledger in the ultimate dissolution, rather than a basis to deprive the plaintiff from their equitable share?
So it doesn't deprive plaintiff of an equitable share.
It goes into the final accounting of the dissolution and wind-up, doesn't
Yes,
it?
it does, of course.
Okay.
The motion trial judges erred in not finding the plaintiff did not breach his guarantee. His breach of that guarantee was a breach of the partnership agreement, a breach of the plaintiff's fiduciary duty as a guarantor, a breach of the duty of loyalty, and a breach of the covenant of good faith and fair dealing. There are numerous instances in which the motion and trial judges failed to apply the plain terms of the contracts between the parties, having wrongly satisfied himself that the plaintiff had fulfilled his promise to guarantee by the power of his signature. The motion judge effectively rewrote the partnership agreement to assert that the partnership agreement, quote, provided that part of CLARKE's company's monthly rent payment would be treated as a further stream of capital contributions by CLARKE to the trust. While the partnership agreement does include provision in paragraph 4 by which part of that rent would be treated as a contribution by plaintiff to the trust, it was exclusively in exchange for plaintiff's guarantees of the note, mortgage, and the lease. As I've established, he did not guarantee the note and mortgage, and he breached his guarantee of the lease. Thus, plaintiff did not increase his beneficial into the trust by virtue of his company's rent payments. The trial judge recognized in finding of fact 23 that under terms of the partnership agreement, plaintiff was responsible for managing the property. She also found that plaintiff started working out the property on February 3, 2015, just 7 months after the trust had signed a 10-year lease with another catering company to occupy that space, and when that company was just 2 days late on their rent. Rather than finding that plaintiff had breached his obligations under the terms of the partnership agreement, the trial judge found that plaintiff, quote, acted in the best interest of the partnership. She does not clarify how plaintiff acted in the best interest of the partnership. While she goes on to state that the tenant's, quote, ability to generate rental income to the trust impacted the trust's profit, she does not elucidate how moving into the tenant's premises and booking their business for his own account in any way helped the tenant to generate income to pay the rent. The tenant paid utilities for the leased premises until June of 2015. Plaintiff and I established Classic Catering Concepts in May of 2015. Classic Catering Concepts occupied the same space that plaintiff's company and the former tenant occupied. Plaintiff remained in contact with the former tenant through July of 2015. In August of 2015, the electric company cut service to the property. Plaintiff would have been well aware that he, and only he, had been using electricity on the premises since February of 2015, would know that he had not paid his own company's utility bills in full, which was a term of his lease in which plaintiff had guaranteed, and would know that any quote-unquote old liabilities were thus his and only his. Yet he represented to me that we will have to pay those old liabilities. Neither I nor CCC bore any responsibility for those old liabilities, and plaintiff defrauded me by taking the money I moved and using it to pay his own old liabilities. Plaintiff also represented to me that CCC did not have enough funds to pay rent, while diverting income to the company to his own account and providing catering services for free. Plaintiff's actions robbed me of the fruits of our business. Plaintiff had a fiduciary duty to me as a director of a small business, and he violated that fiduciary responsibility by taking for himself opportunities that belonged to the business we had formed. He defrauded me by concealing information in which I could have acted, and in so doing, robbed me of the benefits I was entitled to as a partner in the business. In late 2017, when the parties were shutting down CCC, plaintiff sold the catering equipment that CCC had been using. This was the same equipment that plaintiff had left on the premises when his company's lease ended, the same equipment that he had guaranteed would be deemed abandoned if left on the premises, and the same equipment that plaintiff had subsequently sold to the successor tenant and purportedly reclaimed under his security agreement. In finding of facts 59 through 92, the trial judge laid the basis for piercing CC's corporate veil, and did so in finding of fact 127, when she found that Murphy and Clarke were equally liable to the trust for outstanding CCC expenses, that CCC's debt to the trust was owned by both parties, but the trial judge erred when she found under breach of lease that I suffered no damages as a result of CCC's failure to pay rent, because plaintiff and I had an equal stake in the profit and losses of the trust. Because the trial judge failed to acknowledge the trust's schedule of beneficiaries, she failed to recognize that I owned 98% of the interest in the trust, that I was disproportionately harmed by CCC's failure to pay rent. Of the $52,000 in rent due to the trust, I suffered a loss of $50,960 against plaintiff's loss of $1,040. On the promise of guarantees, plaintiff enjoyed 50% of the monies paid by CC to the trust throughout the entire course of its existence. He was only entitled to $476, and I suffered a loss of $11,424. In December 2017, I sent plaintiff...
We'll have to leave it there. We've reached the end of the time. We will rely on your brief for whatever it remains. Thank you.
Thank you, Your Honors.
Good morning, Your Honors. If it pleases the Court, Richard LeClaire for the plaintiff appellee, Charles Clarke. Your Honor, in answer to your question, the promissory note to the Leones was paid off. It was paid off in May of 2013 in connection with the refinancing.
What about the lease? What about the lease?
The lease?
Right.
Well, the argument is that Judge Salinger erred in finding that this non-payment of rent was paid. It's undisputed. Ms. Murphy took the $5,400. There was a conversation between my client and her client. She took the $54,000 because my client wasn't going to be able to work.
When you say her client, she's not a lawyer.
I'm sorry. She took...
The landlord on the lease was the trust, right?
Correct.
Okay. Who paid the rent?
The rent was not paid. There was money in the account, in the trust account, and instead of my client taking his share of that money and paying it back to the trust, Ms. Murphy took the additional money, which she admits 3 years later, in trying to set up a default, she puts the money back in. But the money, there was a conversation, as found by Judge Salinger, on the undisputed facts. I can't pay the rent. So instead of taking his share of the disbursement and giving it back to the trust, because there was money in the trust, Ms. Murphy just took the funds out of the trust for herself. My client did not take a matching distribution.
So in effect, the deficiency, the unpaid rent, was handled as part of the distribution of shared assets out of the trust.
Absolutely, undisputed. And she even admits that in her letter in 2017 when she tries to set up the default. I'm putting the money back in. Now, Your Honor, I've asked for fees in this case, and the reason I am asking for fees. The first argument that they make, that my client somehow is not entitled to his partnership interest because he didn't sign a separate guarantee, is specious. And she knows that it's specious. This trust document, this partnership agreement, was signed in 2004. The first time Ms. Murphy raises this issue is in 2017, 4 years after it's signed off. The partnership agreement...
You say signed off. What do you mean by that?
Well, in 2000, when the partnership agreement was signed in 2004.
No, but you say the first time she raised the argument about the guarantee was in 2017.
17.
4 years after...
13 years after the 13 years after the partnership agreement was signed, 4 years after the note was paid off.
4 years after the note was
And
satisfied.
during this period of time, every year, she's filing a tax return and giving my client his incremental increase in his partnership interest. She does not think there's a problem with this missing guarantee because she knows it's not missing. One, my client signed the note personally, so he's going to provide a guarantee of his own promise to pay the promissory note. Secondly, the partnership has attached to it the relevant documents. There is no separate document that my client was supposed to sign. It's never been presented to my client. To this day, my client still hasn't been presented a separate document, and the partnership agreement doesn't say he'll sign a separate document. It says he will guarantee the note, which he has essentially done by signing it individually, and Ms. Murphy knows this, which is why she didn't raise this issue for 14 years. She only raises it when he is calling on her for freezing her out. She comes up with these ideas. Now, she raises an argument that the guarantee on the lease was breached by my client's, the payment of the rent, which she accepted payment for, which is undisputed as found by Judge Salinger. And she raises that he also didn't pay the water and sewer charges. Now, there was a trial in this case. I think it went on for 5 days. The trial judge found that that was waived. She tries to attempt that as an erroneous finding, but she didn't put into evidence in this appeal, in the record, the entire transcript. I personally told her that she needed to. I said, you need to include this if these are the issues you're going to raise. She didn't raise them. There's no evidence that the trial judge's finding that payment for the water was waived is erroneous. She also seeks to take, even if you assume these things are correct, which Judge Salinger found as a matter of law, she had accepted the rent by taking out the additional, waived the rent by taking out the additional payment, and trial judge is finding that she waived the rent payment. It does not give her the right to take my client's $550,000 in equity in this building. And Ms. Murphy, while she appears pro se, she had competent counsel that she, in the beginning of this case, that counsel had substitute counsel, attempted to discharge him at the trial. The court did not allow it. We had a trial. She had expert counsel. She's a very intelligent person, and she knows that these arguments are specious. She knows they are false. If you read the trial court's finding, this is a continuation of part of her scheme to freeze my client out of this partnership, who was a gentleman in his 60s, not in great health, who needs this asset, and this has all been done to delay that. And I ask you to allow attorney's fees, find the appeal in our favor, and grant it.
You believe your client assumed 50% of the partnership in 2007, 2008, and was treated as such?
Absolutely. He was treated. Every year, the tax returns were filed. Every year, his beneficial interest on the tax return went up. And since between apologize, Your Honor, for not having
2008, 2015, I believe.
I'll tell you, I apologize for not having it at my fingertips. But from 2007 on, Ms. Murphy filed a tax return with the Internal Revenue Service in the Commonwealth of Massachusetts representing that my client had a 50% interest in this trust. They shared the profits, 50%. When they refinanced and paid off the Leone debt, a large pot of money came out, they split it 50-50. Ms. Murphy only made these arguments when my client said, I want to sell the property. I can't cater anymore. I want to sell the property. She came up with these arguments, which she knows are false, and have been rejected, consistently rejected by the courts, and continues to push them at this level, and are consistent as part of her plan to freeze my client out. So being here today is all part of that. If the court has no further questions.
Seeing none, thank you both. Case is submitted, and we reach the last of our cases on the hearing list today. Case number 2023 P519, CHRYSEIS OLIAS Fox versus Peter DOMINIC CLIFT. Just to remind counsel that the case is partially impounded, and please refrain from reference to the impounded material.
May it please the court, Peter Cooper, Sr., represent the appellant and defendant, Peter Clift. We're asking this court to vacate the Massachusetts divorce action and remand it for the issue of alimony once the conclusion of the Louisiana action is done.
What remains in the Louisiana action?
So, the wife is appealing the Louisiana judgment, which dealt with the asset division. Husband has filed an appeal on the court's, the court has agreed or has found, the court is recognizing and is essentially enforcing the Massachusetts judgment with the exception of...
Let me just, I mean no disparagement of domestic relations practice, but this is an example of the cases we sometimes see where the procedure seems to be all over the map. There was a final adjudication on the question of dissolution of the marriage in Louisiana.
Correct.
And that preceded the entry of judgment in the Massachusetts matter.
Correct.
The Massachusetts matter proceeded in the absence of any formal request or protest by the husband.
Correct.
That seems irregular to me.
In an ideal world?
I'm just talking about in an orderly world.
Yes, yes.
In an orderly world, it would seem to me that someone who wishes to preserve the primacy of the first filed action in another jurisdiction, they would file a limited appearance here in Massachusetts and move to stay, and then the two judges would confer on how best for the matters to proceed and engage the parties in a discussion about the orderly progress of the two cases. There's no reason that I can think of why, at least on the question of dissolution, the Louisiana judgment could not stand. I say that. I mean not to encroach in any manner on the prerogative of our counterparts in Louisiana, who will hear what you've described as an appeal of that judgment. Most of the marital assets were here in Massachusetts.
That's not entirely accurate. There's a house in Massachusetts, a house in Louisiana. Husband has several retirement accounts in Louisiana. So,
Okay,
regardless of, so you have some bank accounts that are in
okay, but in the absence, again, there's some question if the question of what would be the appropriate forum for division of the marital estate should occur, all of those questions might have been addressed, but they weren't. Why isn't that a waiver?
Well, it's not a waiver because the question is whether it was error of law for the judge to have done it. And yes,
In the absence of any, request, I mean, look, we deal with criminal matters where a waiver, to the extent it remains, is almost imperceptible. But waiver is alive and well on the civil side of the house, and in the absence of a request by a party that the judge do something, I'm not aware of any requirement, and I mean, obviously if it goes to jurisdiction, this doesn't go to jurisdiction. At most, it goes to forum nonconvenience. There is no hard and fast requirement.
well, the court has inherent powers to control its own docket.
Oh, I know. Look,
right?
the court has the authority to do that, but you're assigning error to something that would have been a discretionary call, even if it had been raised. And when in the absence of a request, the failure to exercise authority is hardly an abuse of discretion. The failure to exercise authority to do something that hasn't been asked, how is that an abuse of discretion?
Well, because again, I think it's more of whether it's error of law as opposed to abuse of discretion. I don't disagree.
Just a moment.
I'm sorry.
Here we are. Yes, I thought momentarily I saw the dreaded blue screen, and I thought we'd lost our colleague. Okay.
So I don't disagree that the first file rule is discretion. I don't disagree with that. I acknowledge that. But
Okay.
the case is still.
Tell me then why it is an abuse of discretion for a judge not to take an action that they have not been asked to take.
Okay, again, I think I'm arguing it was error of law. And the law is the first file rule should be done, should be applied, and
If it's requested, do you have any case where there was an application, where there was error assigned to the failure to apply the first filed rule, as you describe it, in the absence of a request? Any case anywhere in the world?
I could not find a case.
I'm not surprised.
Whether or not.
I'm not surprised.
Whether the court should have done it, whether it was asked, or whether it was not asked to respond.
When's the most recent case you found where it was actually applied?
Sua sponte? Or
No,
just
at all.
There was the Adams v. Giselle. It was a 2022 Rule 128 decision, but it was still this court. It was an issue of Montana or Massachusetts, and it was decided on form nonconvenience, but there was the footnote that said it could have also been done by the first file rule. And the problem is, and again, I acknowledge.
Have you found any case where it has been applied in the absence of a request?
I could not find one
I'm
either
not
way.
surprised about that either.
I could not find one way or the other.
Okay.
However, you know, the wife also didn't ask Louisiana to stay at action. So the problem is, as you know, we have two judgments, conflicting judgments.
Well, they're not conflicting. We have a Louisiana judgment that addressed dissolution, and we have a Massachusetts judgment that addressed dissolution in the same manner, right? It's not conflicting. It dissolved the marriage, and then divided the marital estate.
Both states divided the marital estate differently.
So the Louisiana case then proceeded to division of the marital estate in the absence of any action in Massachusetts, or after the Massachusetts case had done so.
Right. My understanding was, so Louisiana issued the divorce judgment, just on the divorce. Then that case was pending.
Right. That's the record that we have.
Right. And the case was pending. Massachusetts then had the trial, and then after that, after, you know, the brief was filed and everything, then Louisiana, there was a trial, wife appeared by Zoom, and now we are where we are right now.
Well, I can't speak, and I can't speak to what will happen in the Louisiana appeal. All I can do is deal with the case that we have in front of us. But the Massachusetts case proceeded to judgment on dissolution, consistent with the Louisiana matter, and then went on to divide the marital estate in the absence of any request by the husband that it not do so. Right?
In the absence of, yes.
So now we can review the substance of that, and maybe we should turn to that while we still have some time left. But once that judgment enters, is it entitled to full faith and credit?
Louisiana's?
No, Massachusetts on the division of the marital
No,
estate.
but full faith and credit, meaning Louisiana recognizes
Louisiana would ordinarily be required or expected to give full faith and credit to
which it
Massachusetts.
did, and now husband has filed an appeal on that.
Ah, okay.
That's what happened, so.
I get it. Okay,
and the
so now
state-
let's move to the merits then of this case is getting a little bit easier in terms of trying to find a pathway out of the briar patch.
Yeah,
Before you move on, though, before you
sorry?
move on, I thought there was a remand from the appeals court in Louisiana on that issue. You say it has been resolved?
Right, so got remanded. Louisiana then issued an order recognizing the Massachusetts judgment on an executory.
Sanity prevails.
Except the alimony. Apparently what's going to happen is, because the alimony is modified in Massachusetts, that they wouldn't full faith and credit and say it was executory. So what's going to have to happen is, I know this is well beyond this, but I'm just explaining. What's going to happen is, my understanding is, wife's going to have to get the divorce contempt judgment from Massachusetts and then file a separate proceeding in Louisiana.
Okay.
I know it's all over the place.
Let's talk about your challenges to the division of the estate and the alimony award here in Massachusetts, because those are separate substantive issues if we get past your claim of legal error on entertaining that question to begin with.
Yes. So when you view it as a whole, okay, wife got about, 65% of the marital estate. I think it was 1.8 million versus $1 million. Then she got 35% of the gross incomes lifetime alimony, and she got about, I think around $76,000, all of legal fees that she incurred, which, first on the legal fees, she would have incurred that one with the other, because if it was in Louisiana or Massachusetts, it was the same thing. And that's kind of why you had the first file rules, because you don't have, legal fees in two different cases and stuff. But in any event, so if it was just 63% division of the assets, that was it, I don't think she would abuse her discretion. But the whole financial, so you have that, then you have the alimony, which is, under the statute, it's 30 to 35%, but that was before the tax laws changed. So at the time, alimony was deductible by the payor and taxable to the recipient. That's changed. Everyone knows, at least in the probate court, everyone's aware of that. That it's no
But
longer.
everyone being aware of that doesn't mean the judge can take judicial notice. In a recent opinion, I believe Justice Sachs and Jones of last term addressed that very issue, that the judge can't, again, just take judicial notice of those changes. There needs to be some evidence.
Um,
Do you agree with that?
I would agree with that. So she didn't have to, but she could have, right? I mean, she could have said, okay, it might not be, you know, I'm not going to do the tax effect. I don't have a tax actor to say, okay, the equivalent of 35%, when it's no longer tax deductible or taxable would be this. I'm not suggesting that. What I'm saying is it was just 35% is a large number and a lifetime alimony. So I'm just, my argument is when you look at it as a whole.
But you weren't there, right? So he wasn't there and he wasn't represented. And so in part, why legal fees were so expensive, but also why these arguments weren't made to the judge who can't take judicial notice, because your client opted to be absent. So we're stuck with what we have, which is what it is, right? Good argument now, it just wasn't made to the judge.
Unfortunately, you're correct. I mean, unfortunately, right. But can I just quickly go back to the question about first file, about the discretion? Even if you got to the, if you find that it wasn't error of law, but instead abuse of discretion, I still think she still abused the discretion, because when you look at the case law, when you look at, I think, W.R. Grace and talked about the factors, I think all that shows that it was abuse of discretion, that she should have done that.
Considering the evidence of the wife's health, you don't think that would be an exception? It's not a hard and fast rule.
But that was done, but that was, that would have been brought up. I wasn't obviously at the Louisiana. I'm assuming that was brought up at the trial in Louisiana. There was a trial on the same issues on the asset
What I mean on
division.
the first file issue, for a judge to consider whether to stay the matter, she would have considered exceptions to the first file rule, and there are exceptions to it, correct?
Yes, there are exceptions to it, but I don't think in this
It
case.
would have been a hardship, perhaps, the judge would have found, based on the wife's physical disability, to attend proceedings or trials in Louisiana. She could have found that.
Well, she appeared at the trial by Zoom. So I don't know what happened on the other hearings, because I wasn't there, but I am aware that she participated by Zoom. I'm assuming that either she did or could have similarly appeared at the hearings in Louisiana, or maybe they could have excused her appearance, which oftentimes we do here. But
So I want to make sure I understand your legal argument. You would want us to write something to tell all the judges that if not raised and nobody makes mention, a judge will be found to have committed reversible error if he or she does not sua sponte determine and then issue a decision on the first filing premise.
if the factors, the W.R. Grace, the private and public factors, outweighed.
No, just to go through the analysis. So nobody says anything about Louisiana. Judge here in Massachusetts looks, or that's said, but nobody asked. What we would be telling the judges is, independently, whether people want it or not, you need to review and make a determination that nobody else has filed in any other state first, and then do the analysis.
Well, she was aware. There's no, everyone was aware of Louisiana. Everyone was aware there was a Louisiana action.
But you understand what we're writing for is applicable to future cases. So judge, and all judges out there, you have an obligation, even if nobody wants it or asks it, to go through this analysis. And if you don't, it's reversible error.
Correct.
Error of law.
Correct.
All right, thank you.
Thank you. Appreciate it.
We'll hear from counsel for the wife.
Good morning, Your Honors. May it please the Court. My name is Nicole Barrasso, and I represent the plaintiff appellee, CHRYSEIS Fox, who is here in the courtroom today. Before I begin the presentation I prepared, Your Honors, I just wanted to clarify for the Court the procedure, the status of the procedure in Louisiana. On July 28, 2023, an appellate court in Louisiana reversed the trial court's decision there, making the Massachusetts judgment stayed to the extent the court had the authority to do that, and remanded the case for consideration as to whether or not the Massachusetts judgment should be made executory in Louisiana. On November 3rd of 2023, the trial court in Louisiana did in fact make the Massachusetts judgment executory in Louisiana, and I'm happy to supplement the record if...
And there's an appeal of that determination that's pending in Louisiana?
Not exactly, Your Honor. So my understanding is that in December, husband's counsel in Louisiana filed what's called a motion for suspensive appeal, which, as I understand it, asks the trial court for permission to pursue an appeal with the filing of a bond. And then it sounds like there was some sort of procedural irregularity with that motion being allowed because the order that came out of the trial court didn't set the bond.
I really affirmatively don't want to hear anything more about
Understood.
Procedure in this case.
Understood, Your Honor. I'll just
But I
continue
would ask
on.
you to supplement the record with what occurred in November.
Just maybe a copy of the docket.
I'm sorry. Okay, yes, I can supplement the record with those two
Very good.
documents. Thank you. Now, as Your Honors are aware, this case involves parties who have been married for 27 years. As I mentioned, my client, Ms. Fox, is here today. She's 63 years old. The court has already recognized that she does have significant medical issues and disabilities. Her physical condition is fragile. She's extraordinarily prone to injury. She spends a substantial amount of her time seeking out medical care, traveling to medical appointments, and her financial condition is also fragile, despite the pronouncements about the value of the estate that was awarded to her in the judgment. The reality is that her disability and Social Security income are about $633 per week. In 4 years, part of that income will go away when she loses her supplemental disability policy. She has heavy out-of-pocket costs relative to her medical
So
care.
we're familiar with all of that as part of the record.
Okay.
Thank you. No, we're familiar with that.
Thank you,
I'd
Your
like to
Honor.
maybe address the issue. You've heard us question your brother about whether or not his client has waived the issue of first file.
Yes.
What is your position on that? First, I know you argue he has waived. So your position, he's waived that argument by not appearing.
Unquestionably, Your Honor.
And he's not challenging personal jurisdiction, correct?
He is not. He's not challenging.
And what about subject matter jurisdiction?
There is no challenge to that either, Your Honor.
And for first file, could that not be seen as a precursor or perhaps a proxy for subject matter? Because essentially, if a judge were to stay and the matter were resolved in a different jurisdiction, different sovereignty, and it were resolved, there would be claim preclusion. There would perhaps not be subject matter.
I think that's correct, Your Honor. And I agree with statements the court made earlier, and that it is a discretionary decision by the judge here that involves the weighing of a number of factors in terms of which sovereign, where the case should be, so to speak. There is no hard and fast.
More like forum nonconvenience than it is subject matter jurisdiction.
Well, yes, Your Honor. Yes, it is. In terms of subject matter jurisdiction, I don't think there's any question there's subject matter jurisdiction here under the statute, which I cite in my brief. The marriage occurred here. The parties were married here. The bulk of the marriage occurred
But
here.
one could imagine a framework in which the filing of an action in another case that also has both personal and subject matter jurisdiction would operate to deprive any other forum of subject matter jurisdiction over that matter. That's not the rule as I understand it, but one could imagine that.
Yes, Your Honor. That's true, but that was never raised here.
But one can't waive subject matter jurisdiction.
Well, that's true, Your Honor. No, that can't be waived, but there's no challenge here on appeal to subject matter jurisdiction. There's no challenge to it.
Challenge, treating it as error of law seems to rest on a premise that treats the first filed rule as the equivalent of subject matter jurisdiction.
Yes, I agree
That's not
that's the
the
premise.
law, you say.
No, I do not think that is the law. I do not think that is the law at all. I mean, the first filed rule, and I don't think it's actually a rule. I think it's a principle that can be applied with or without, with the court's discretion. But no, that's not the law. The rule exists to deal with the circumstance when two jurisdictions do have subject matter jurisdiction, when two sovereigns do. I don't know Louisiana law. Presumably, the court there determined there was subject matter jurisdiction, but the issue is which court should hear the case, which court should divide the assets, which court should determine alimony, and clearly That's Massachusetts. The heft of the marriage occurred here.
So you'd say even if Louisiana got to the assets first, Massachusetts would still control?
Potentially, because I think my client has, and she raised the objection below in Louisiana that there's no personal jurisdiction over her. She's done everything she's supposed to do. She retained counsel in Louisiana who filed what's called exceptions to the complaint for divorce, filed a motion to make the mass judgment executory. I mean, numerous objections. I know Your Honors do not want to hear any more procedure, but frankly, I believe her counsel there has bent over backwards to preserve her appellate rights. And so regardless of whether or not the Louisiana court entered a judgment, she still has appellate rights, and those are being preserved, and the determination still has to be made, potentially, which court should prevail, which court has the better bite at the apple, so to speak. Now, in this particular case, with regard to this so-called first filed rule, it's not a rule. The case law is clear in Massachusetts, and some of the cases are old, but there's still good law, that people have a right to file a lawsuit so long as the court does have subject matter jurisdiction. She has a right to pursue her case here. This is where the bulk of the marriage occurred. This is where she's lived. She has almost no contacts with Louisiana. Furthermore, one of the cases specifically identifies as an exception to that rule that there's been some sort of fraudulent behavior, so to speak, by the party who filed out of state. And I would argue that in this case, the husband sending her love notes just a couple of months before he filed divorce, you know, he clearly tried to mislead her into believing that the marriage was still viable, and you know, as a result, she was shocked by the divorce filing, and as I said, did everything to preserve her rights. She filed a complaint here in Massachusetts within the month. More importantly, Your Honors, what hasn't been touched upon is the reality that the husband today is coming into this court seeking relief when he hasn't followed any of the rules, for the most part, that were set by the court or the judgment that was issued in Massachusetts. At this point today, he owes over $20,000 in alimony to my client. He owes over $77,000 in attorney's fees. A capias issued for him last July. His last known whereabouts are in Europe. He has no other really known assets in Massachusetts that she can attach to try to preserve her recovery and preserve her right to get the support that she is entitled to and that she desperately needs. It's not even clear he has a presence in the United States anymore at this point. And there are several cases, one in particular, Yusuf versus Yusuf, which is almost directly on point. And in that case, this court said that that man could not continue with his appeal until he posted a bond. Now that was a divorce division of assets matter, just like this one. And after
You haven't made any comparable motion along those lines here, have you?
Yes, I did, Your Honor.
To dismiss the appeal on the ground that he
Yes, I
hasn't posted
did.
a bond? Okay.
I did. That was the first thing that I filed, actually, in response to the appellate brief filed by my brother. I filed my reply brief, and I filed a motion to dismiss under Rule 15, and then I was notified that that was not the right way to do it, so to speak, and so I filed a revised brief which contains the same arguments.
We will review that as well.
I appreciate that, Your Honor. And just to note for the record, there's another case as well, Summer versus Manga, in which there was a contempt of a judgment issued by a trial court, and the appeals court required the party to purge that contempt. It had to do with hiding of assets before his appeal was allowed to proceed. So, just continuing on, Your Honor, Your Honors, there are two main arguments, two main baskets that my brother's arguments fall into. One is what I call the sua sponte arguments, which this court has already addressed at length with my brother, and I'm happy to comment on the waiver issue if the court deems it's necessary. With respect to, in particular, the tax claim that the court should have sua sponte taken notice of the effect of the Tax Cuts and Jobs Act and the non-deductibility of alimony, I would just like to add that not only did he not raise that issue below, it's not even clear at this point where he's paying taxes. As far as we know, he spent all of 2023 in Europe. I don't know if he earns income in the United States anymore. I don't know if he pays taxes in the US or in Massachusetts. So for the trial court to have decided to take judicial notice of a statute in the absence of husband's participation would have been completely speculative, when at the time of trial he was believed to be in Germany, and that was the information provided to the trial court. The second basket that my brother's arguments all fall into are the abuse of discretion arguments. And I think the record below and the detailed factual findings by the judge more than support her determinations as to asset division and alimony in this particular case. It's clear that the judge contemplated all of the statutory factors for both asset division and alimony. There's no dispute. I don't think there can be any dispute that my client, her need is exceptional. The husband has the ability to pay. Her prospects for the future are rather dire, while his are robust, given his fairly exceptional background and employment pursuits. With respect to attorney's fees, the last point I'd like to address before the court, again, that's another discretionary issue for the trial court. Now, that under Chapter 208, Section 38, the issue on attorney's fees is also need and the parties' relative abilities to pay in their relative financial picture. The court is obviously well aware of the disparate circumstances the parties are in, but I think that those also support the award of attorney's fees in this particular case. The judge was aware and made a comment in the transcript that she knew the trial was proceeding in Louisiana and that my client was continuing to incur fees in Louisiana as well as Massachusetts. The court did not order all of her fees to be paid by the husband, but just a portion of them. And the court that heard this case at trial, that ordered the fees, had also handled all of the pretrial proceedings, at least from the time I entered my appearance in early 2022. So she was intimately familiar with the work that was performed, with the many motions that had to be filed, with the out-of-state work that had to be done. She observed our performance throughout the case. She was provided with a 29-page single-spaced affidavit of fees, and as such, I believe that all of the different elements are met to support that award of attorney's fees in this case. If the court doesn't have any further questions, I will conclude.
Seeing none, thank you both. That concludes the argument in this case. The case is submitted, and that concludes our session as well. We are adjourned.
Thank you, Your Honors.